beginning of next year, once we have dealt with all the winterization and also the energy crisis and everything that comes with it. I also like to briefly address an issue which was mentioned, I think, in the German presentation about discrimination between asylum applicants and beneficiaries of temporary protection directive. I think we have to make clear that there are certainly differences because these are two different systems. The temporary protection is meant to come into play when we have a large influx of people within a very short amount of time, and therefore we have developed a specific different regime. So there are differences, and differences do not mean that we discriminate. We simply have two systems, and we apply the asylum for a more regular structural influx of people, but for a sudden and a very large influx we have the temporary protection directive. Of course, it is important to bear in mind when you grant certain let's say benefits, to make sure that maybe the divergence between the asylum applicants and the beneficiaries of temporary protection are not too big. But there is one very clear divergence, and that's about access to the labor market. Normally, asylum applicants cannot access immediately the labor market because they are waiting for a confirmation of their status. They are applicants. In the case of temporary protection, you're not an applicant, you are a beneficiary already from, let's say, early on. And that means that for that reason, you can access the labor market much easier. And that is a difference which is a difference that stems from the law. And that is important to underline that difference exists, but it was never meant, I think, to discriminate against any group. It may maybe call for reflection on how to deal with asylum applicants. On the information to be provided at the border, we know that the Asylum Agency has made huge efforts to work on information leaflets and also to make sure that they are available at the borders. But of course, there may be situations where this does not work in the way it should, and therefore we're very grateful for all the information we get all through this forum, but also through other channels. And I think, Chair, by this I have basically addressed, I think, the majority of questions which seem rather permanent, I would say pertinent in this matter. Many thanks. And of course, questions for children and unaccompanied minors, that Isabella is much better placed than I am.
Thank you again. Thank you very much, Cecilia. We will we would be very pleased if you can join us later at the end of the day, but you are excused in case you have some further commitments. So quite, if possible, quite to the point, but Isabella, because she has provided a lot of information in the chat, and then so that we can have a quick round, Isabella, Jadwiga, and Gemma. Thank you. Isabella? Isabella, we cannot hear you. I think you have your microphone muted.
Can you hear me now?
Yes, we can.
Okay, perfect. No, I was muted by the organization, but it's no problem. Look, I wanted to start before going into the different issues that I put in the chat, and maybe some people do not see because they are in the room there. Just to, if you allow me a suggestion, I think that we would warmly recommend to all of you to read the materials that are published on the website of DG Home with respect to the implementation of the Temporary Protection Directive. There is a very useful section on frequently asked questions, which addresses many of the legal issues that have been raised by some of you in the room. And there is even more further important information there. So I think that it really would be very useful. I put in the chat the link, but you can also find it very easily with Google. If you Google DG Home Temporary Protection Directive implementation, you will find it very easily. There you will also find the frequently asked questions about unaccompanied and separated children that I linked to you before. So basically, there is this link to the general questions. In the same section, you will also find the frequently asked questions about the unaccompanied and separated children, where you find the answers to the questions that have been raised with respect to the recognition of the guardianship papers originating from the Ukrainian authorities. And there was a comment from someone in the room about the fact that there is a risk that sometimes these papers are either not authentic or they should be questioned because they have been given to the people in questionable circumstances. It's a fair point, and there is always a risk, but this is, I mean, we are in a room of lawyers, and you cannot apply a negative presumption to everybody just because there can be some cases of abuse. In cases where there are suspicions that the papers are not in order, obviously checks can be made. But the general principle here is stemming from the fact that I mentioned before. I mean, our countries and Ukraine are all signatories of the 1996 Hague Convention, which addresses many issues related to parental responsibility and authority, cross-border issues. And there is an obligation that we have all committed to automatically recognize guardianship papers issued in Ukraine by the competent authorities. So it is a matter of seeing if indeed the authorities who issued the papers are the ones who are competent in Ukraine to issue such papers. And like I mentioned before, on the same frequently asked questions, you will find also a link to information that was provided in this respect by Ukraine itself. So they compiled themselves a list of the legislation applicable in that respect in Ukraine, and a list of the types of courts and administrative bodies who are entitled to issue guardianship papers, and some even models of such documents, how they look like in reality. So all this information that is very useful is provided in the section that I mentioned before on the interpretation of the temporary protection directive. I think that there was another question which was interesting about what happens to the unaccompanied minors who are aged 16 and 17. There is actually the issue that you mentioned, the one of whether we should appoint or not a guardian for these kids. But there is also a related one. Some of these teenagers are traveling to Europe alone. It needs to be said because Ukraine has a law under which teenagers from the age of 16 and above do not need parental authority to travel abroad, okay? So from the perspective of the Ukrainian law, it is okay for them to travel abroad without papers from their parents. Now, once they arrive in Europe, this does not match the reality and the legislation that we have in Europe. Your question was, do we have EU law which allows for the possibility not to appoint guardians for them? The answer is no, because the temporary protection directive provision on the appointment of guardians does not offer such a possibility. So it is compulsory to appoint a guardian until the age of 18. Having said this, I mean, if you look at the, for example, comparable similar case of what happens to asylum applicants, under the Asylum Procedures Directive, there is a possibility not to appoint a guardian when a child is from 17 to 18, okay? So that would be a little bit of the similarity, but as I mentioned, under the Temporary Protection Directive, there is no such possibility. Having said this, one can always look for practical solutions to make this bureaucratic requirement a little bit lighter for the case of the older teenagers. So there are many examples that we know in many member states where the children are actually 17 or 18. Sometimes they are already coming to initiate university studies in Europe because they have the age to do so, and they fulfilled their bachelor's degree, their baccalaureate, how should I put it, you know, they finished high school in Ukraine. So now they intend to come to Europe to initiate studies or continue studies already initiated in Ukraine, university degree. Obviously, they do not need the same kind of care and follow-up like a younger child. Nevertheless, somebody should be appointed to preserve, let's say, not to preserve the legal requirement, but to make sure that there is somebody available for this child in case, just in case there is a need. You never know. It can happen. It doesn't have to be heavy work because they don't need to go every day to check on these kids. They can have a certain degree of autonomy, that is for sure. But there should be somebody they should be able to contact in the host member state in case they need some guidance or some sort of support with paperwork or anything of the kind. So it's not a bad idea to have a guardian. Obviously, the workload of this guardian is going to be lighter for these kids. That is the final point I wanted to make on the subject.
Thank you very much, Isabella. If Gemma would you like to say something?
Sure, I'll come in just very briefly and not to delay your lunch much longer. But there was a particular question about the obligations of the state to ensure voluntary return and what does that in practice mean? I mean, from our perspective, it's important that any decisions to return are, first of all, fully voluntary and that people are fully informed before they take these kind of decisions to return at the current time. So what we could expect states to be doing, particularly important in that respect, is sharing information. So not only sharing information about the situation in Ukraine, but perhaps sharing information about the impact of return on people's legal status and their ability to re-enter. And I think this is, we've spoken about it a little bit today. I think it's a key question amongst members of the community that will help them make these kind of decisions with the full information in front of them. Also, one thing that states might seek to do in terms of this kind of pre-departure counselling or provision of information is to try to identify particularly vulnerable groups amongst those who are seeking to return, to ensure that perhaps they have specific needs that need to be catered for upon return, trying to make those linkages with services on the other side of the border, but also ensuring that people in more vulnerable situations who are at heightened risk, again, are making these decisions fully voluntarily with all the information in front of them. And as colleagues have mentioned, the directive does have this provision that it's relevant for states to be considering go and see visits. That's often one way that refugees are assisted to make these kind of decisions in the longer term, to go for a short visit, see how the situation is, come back and share information with their family and the wider community that will help inform wider decision making. If I may just take one more minute to talk about the situation of children, because I believe one speaker talked about the situation of returning children back to Ukraine. I think this is quite an important point because we have seen some instances where children who have left Ukraine under different kinds of guardianship arrangements, perhaps from institutional care, have then been returned back to Ukraine. Perhaps just one point to make clear here, as much as under the Hague Convention states agree to automatically recognize guardianship arrangements from other countries, that doesn't mean that the hosting state has no obligations towards those children. Obviously, unaccompanied and separated children, they need to be registered with the National Child Protection Services. The state has obligations towards children under the Convention on the Rights of the Child. And this includes ensuring that any decisions made are made in light of the best interest of those children. So if there is a decision about returning back to Ukraine, in the case of unaccompanied and separated children, those decisions should be made by national child protection agencies following a formal best interest determination procedure, which is owned by the National Child Protection Authority. So I just wanted to add that point there. I'll leave it there. Thank you very much.
Thank you very much, Gemma. Last Jadwiga Masinska, if you would like to add.
Thank you very much. I will be extremely brief since I believe there were no specific questions to the EUAA. So just to, from my perspective, to ask the participants in case they would be able to indicate some areas where they would need the EUAA to provide more research, to provide specific outputs, or to provide specific overviews of how a certain element of temporary protection or otherwise is being implemented by the member states. We would be more than happy to consider and to provide that. So just to kind of provide this offer and ask kindly the participants to give us this feedback when they have a chance, either in the afternoon or maybe later by email. Otherwise, I believe there wasn't a specific question to the EUAA, so I do not want to stand between you and your lunch.
Thank you. Thank you very much, and thanks to everybody. I think there were some also questions in the chat, but we can handle them afterwards. Otherwise, we will miss our lunch. And I want you back to be here at 2 o'clock. So lunch is served here on the side. And thanks a lot to all the speakers until now that have been with us, also the interpreters and the technical team. So thanks a lot. We resume at 2.
raz, dwa, raz, dwa, trzy, raz, dwa, trzy, trzy. Raz, dwa, trzy, raz. Raz, dwa, trzy, trzy, dwa, raz, 10, 9, 8, 7. Raz, dwa, trzy, trzy, dwa, raz, dwa, trzy. 33, 34, 35, 36. Nie ma. 37, 38, 39, 40, 42, 40, 41, 4. Raz, dwa, trzy. Raz, dwa, trzy, 33. Hej, raz, dwa, trzy, dwa, raz. Tu raz, dwa, trzy, 10, 9, 8, 7. Test. 33, 32, 33, 34, 334. Test. Raz, dwa, trzy, raz. Raz, dwa, trzy, raz, dwa, trzy, 4. 4, 5, 6, 7, 8, 9. Tutaj też nie słychać. Tu w odsłuchu też nie słychać. Tu nic nie słychać na razie. W tych raz, dwa, trzy, raz, dwa, trzy. A, B, C, D, E, F, G, H, I, J, K, L, M. 4, 5, 6, 7, 8, 9, 10. Hej, raz, dwa, trzy, hej. 31, 32, 33, 41, 43. Słucham? Może. Raz, dwa, trzy. Raz. Jak blisko mikrofonu jestem, to może sprzęgać. Raz, dwa, trzy, raz, 3, 33, 32, 30, 34. Teraz za cicho jest chyba. Bo jak tak normalnie siedzę, to... Raz, dwa, trzy. 33.
So we are going to resume. Okay. So thanks for coming back. Actually, I see is there coffee outside still?
Yes. You want to take coffee? I will do coffee.
Okay, so thanks a lot for coming back here. And we resume now the session. And I would like to introduce Julia Chervatiuk. She's working with the Ukrainian NGO Right to Protection. I understand that Right to Protection is working very closely with UNHCR in Ukraine, almost functioning as its operational arm there. I would like to also personally thank Julia, because I know it was not an easy trip coming from Ukraine to reach here Warsaw today and to be with us. And I also understand that Julia is going to speak in Ukrainian. So for those who cannot understand Ukrainian, including myself, as I'm Spanish, I'm not very good in Ukrainian. So please use your devices, is channel 2. So Julia, in case you want to also give more information about yourself as well, you can do, and thanks a lot for being with us.
Thank you, Anna. Мабуть, треба включити. Добрий день ще раз. Я дуже рада бути присутньою сьогодні тут. І дуже дякую всім організаторам за організацію цього заходу, за можливість виступити, за можливість почути і бути почутою, тому що це дуже важливо наразі не тільки для України, а і для багатьох інших країн, тому що наразі ми усі стикнулися з дуже великою міграційною кризою, і швидке реагування на такі виклики якраз буде не тільки доречним, а буде дуже правильним в правовому полі. Україна є підписантом багатьох міжнародних документів і, відповідно, має обов'язок, так як вона їх ратифікувала, обов'язок їх виконувати. І одним із таких документів є Конвенція про статус біженців. Ми будемо говорити сьогодні не тільки про громадян України, які змушені були залишити територію України із-за широкомасштабного вторгнення Російської Федерації, а і про інших громадян, про яких уже сьогодні говорилося, які також стикаються з проблемними питаннями, і з такими питаннями стикаються в першу чергу країни, на територію яких такі громадяни перебувають. І сьогодні я дуже швидко розкажу про ті меседжі, які адвокатує наша правозахисна кампанія Right to Protection. R2P. І що ми поговоримо також і про позитивні зрушення, які відбуваються. Тому ми сьогодні окреслимо питання доступ до документів українців на території Європейського Союзу, документи біженців та осіб, яким надано додатковий захист, які видані в Україні, і особи без громадянства та недокументовані особи, які перебувають під ризиком без громадянства. Тобто зараз багато юристів на території Євросоюзу, в тому числі, стикнулися з тією проблемою, що прибувають особи з території України і є нерозуміння того, які в них документи і що ці документи означають. І якраз це ми сьогодні і будемо намагатися з'ясувати. Ну, по-перше, те, що я вже зазначила, це про доступ документів українців в Європейському Союзі. Були вже певні зрушення, тому що в квітні цього року R2P за сприянням ЕКРЕ та ХІАС поширили наступні повідомлення щодо доступу до документів українців в Європейському Союзі. Це питання те, що українські водійські посвідчення повинні бути визнані дійсними на період тимчасового захисту в Європейському Союзі. І це перше питання і перший меседж R2P був успішно виконаний. Тому можна говорити про те, що ми все-таки спостерігаємо позитивні зміни в визнанні українських документів, але ще є питання цифрових документів в додатку «Дія», які прирівнюються, які повинні прирівнюватися до паперових в Європейському Союзі. Ну, щодо цього питання, українська сторона докладає багато зусиль для забезпечення такого визнання. По-перше, найближчим часом буде здійснено переклад на англійську мову закордонних паспортів, технічних паспортів на транспортні засоби та посвідчень водія у додатку «Дія», про які, я сподіваюся, ви чули. Крім того, за інформацією Міністерства цифрової трансформації, триває процес забезпечення перекладу на англійську мову всіх документів у цьому додатку «Дія». По-друге, 16 серпня цього року Кабінет міністрів України прийняв постанову 910, номер 910, відповідно до якої персональні дані в додатку «Дія» можуть бути передані іноземним державам, і таким чином українці отримують право використовувати електронне відображення інформації зі своїх документів, завантажених у «Дії», для доступу до послуг за кордоном. Ну, це означає, що залишився тільки останній крок, і це якраз ухвалення рішення на рівні Європейського Союзу, щоб було встановлено еквівалентність електронних документів у додатку «Дія» паперовим документам. Друге важливе питання – це документи біженців та осіб, яким надано додатковий захист, видані в Україні. Також в квітні цього року наша правозахисна організація R2P також спільно з міжнародними організаціями просували повідомлення щодо проїзних документів, визнаних в Україні біженців та осіб, яким надано додатковий захист. І такий меседж звучав, що держави-члени повинні визнавати проїзні документи, видані в Україні бенефіціарам міжнародного захисту, як біженцям, так і особам, яким надано додатковий захист. І такими документами для біженців є посвідчення біженця і особи, яка потребує додаткового захисту, і проїзний документ біженця. Незважаючи на те, що, на думку юристів з країн Європейського Союзу, невизнання проїзного документа для, наприклад, отримання віз не перешкоджає наданню тимчасового захисту на підставі цих документів, ми все-таки вважаємо за необхідне продовжувати просувати цей меседж для того, щоб не було додаткових складнощів. По-перше, в ситуації вимушеного переміщення в пошуках безпечної країни біженці повинні бути захищені від перешкод, що виникають через невизнання їх проїзних документів, тому що у цих осіб є право на свободу пересування. По-друге, їхнє право на свободу пересування гарантується Конвенцією про статус біженців, про яку я вже зазначила. І по-третє, не всі країни Європейського Союзу видають проїзні документи бенефіціарам тимчасового захисту. І останнє, не менш важливе, що ні біженці, ні особи, яким надано додатковий захист в Україні, не можуть користуватися паспортами країни походження. І це важливо. Ці документи зберігаються в Державній міграційній службі в Україні протягом всієї міграційної процедури і навіть після надання міжнародного захисту. Тобто вони забираються і залишаються в особовій справі в Державній міграційній службі. Таким чином, проїзний документ особи, якій надано додатковий захист та посвідчення біженця для виїзду за кордон, видані в Україні, мають визнаватися дійсними не лише для звернення за тимчасовим захистом, а й для пересування державами. І таке визнання має відбуватися у всіх європейських державах. Ми зробили певний моніторинг і знайшли, що деякі країни, ну принаймні Нідерланди, Люксембург, Бельгія, Швеція, Данія, Естонія, Ісландія не визнають посвідчення біженця. А Португалія, Швейцарія, Польща, Латвія, Литва, Норвегія, Швеція – посвідчення особи, які надано додатковий захист. Ще один меседж, який ми хочемо сьогодні озвучити, також стосується деяких особливостей документів, що видаються Україною для визнаних біженців та осіб, яким надано додатковий захист. Ці особливості слід враховувати при наданні доступу до TPD. По-перше, посвідчення біженця та посвідчення особи, яка потребує додаткового захисту, не є біометричними та застарілими. Ми маємо такі документи уже як ID-картка, зараз можете бачити. Це посвідка на тимчасове проживання. Але у нас є ще книжечкою, документи книжечкою. І такі документи не є біометричними, але вони не є застарілими. Незважаючи на те, що до 2014 року в Україні були затверджені бланки проїзних документів для біженців з безконтактним електронним носієм, Державна міграційна служба України продовжує використовувати так звані застарілі і не біометричні бланки. І це є законним, тобто законодавством України передбачена можливість використання ще таких документів, які були надруковані фактично. По-друге, термін дії проїзного документа залежить від терміну дії внутрішнього посвідчення біженця та посвідчення особи, якій надано захист. Останнє дійсно протягом 5 років. Ні ті дії, ні внутрішнє посвідчення біженця та посвідчення особи, які надано додатковий захист, не можуть бути продовжені за кордоном, а саме в закордонних дипломатичних установах України. Це те, про що ми сьогодні вже говорили. R2P отримує скарги від бенефіціарів, які перебувають у приймаючих країнах Європейського Союзу. Зокрема, вони стверджують, що їм надається тимчасовий захист лише на термін дії документів, виданих Україною. Вони стурбовані і збираються повертатися в Україну лише для того, щоб поновити ці документи. Однак такий варіант для них є складним та небезпечним. Ми виступаємо за те, щоб документи, видані Україною, визнавалися в країнах Європейського Союзу з урахуванням всіх їх особливостей. Особи без громадянства та недокументовані особи під ризиком без громадянства. Також в травні цього року було озвучено питання і щодо осіб без громадянства, тому що права осіб без громадянства та недокументованих осіб, які змушені були залишити територію України із-за повномасштабного вторгнення Російської Федерації, це питання все-таки залишається актуальним. І основними повідомленнями нашими є особи без громадянства, які вимушено залишили Україну, маючи лише посвідку на тимчасове проживання, повинні отримати тимчасовий захист або інший адекватний захист в країнах Європейського Союзу, поки їх повернення в Україну не стане безпечним. Недокументовані особи під ризиком громадянства, особи з невизначеним громадянством, які змушені були залишити територію України, повинні мати доступ до правової допомоги та інформації щодо їх правового статусу в країнах Європейського Союзу, а також доступ до процедури визнання особи без громадянства та процедури надання притулку. Щодо першого повідомлення, я хочу зазначити, що в 2021 році в Україні запроваджена нова процедура визнання осіб без громадянства. Протягом 2021 року 55 осіб було визнано особами без громадянства. Ще ця інформація може бути іншою, тому що зараз також трохи ускладнився процес доступу до публічної інформації в Україні. Ще понад 700 заяв залишаються на розгляді в Державній міграційній службі станом на 24 лютого. Ми говоримо про те, що українське законодавство поки відрізняється від законодавства європейських країн та країн Європейського Союзу, а тому є певні розбіжності в оформленні документів. Особа, яку визнано в Україні особою без громадянства, документується звичайною посвідкою на тимчасове проживання, яку ви бачите на презентації, без видачі будь-якого іншого документа, що посвідчує особу, як то посвідчення особи без громадянства чи проїзного документа, можуть бути інші документи. Тобто достатньо однієї такої посвідки для того, щоб особа без громадянства перебувала на законних підставах в Україні. Також європейським юристам слід враховувати, що є декілька категорій осіб без громадянства. Це особи, які звернулися за визнанням або були визнані особою без громадянства в Україні, в тому числі з новою процедурою 2021 року, про яку я щойно зазначила. Особи, які прибули і проживають в Україні після визнання особою без громадянства в інші держави, і особи, які фактично проживають на території України, намагаючись визначити належність до громадянства певної держави. Всі ці особи без громадянства на підтвердження свого спеціального статусу в Україні мають або можуть мати наступні документи. Посвідчення особи без громадянства для виїзду за кордон, посвідка на тимчасове проживання, видана особі без громадянства, посвідка на постійне проживання, видана особі без громадянства, довідка про звернення за визнанням особою без громадянства в Україні, тобто це коли особа тільки звернулася за процедурою визнання, але ще не отримала документів. І паспорт громадянина колишнього СРСР зразка 1974 року. І особливу категорію складають так звані, це такий паспорт, який ми бачимо зверху, паспорт гражданина Совєтських Соціалістичних Республік, і посвідка на постійне проживання. Це також посвідка старого зразку, які мають наші бенефіціари. Особливу категорію складають, як я вже зазначила, так звані незадокументовані особи без громадянства. Такі особи складаються переважно з людей, які проживають в Україні протягом останніх 20-40 років, але не мають жодних дійсних документів або мають паспорти СРСР. Таким чином вони не можуть довести, що мають будь-який статус або захист в Україні. І Слід зазначити, що такі особи є невидимими для держави та не можуть реалізувати свої права на освіту, на охорону здоров'я, отримати спадщину, відкрити банківський рахунок, зареєструвати шлюб, вільно перетинати кордони і багато іншого чого. З минулого року такі люди можуть подати заяву в Україні на визнання статусу особи без громадянства за новою процедурою, про яку я сказала. Але ця процедура є новою і тривалою, так як вона триває від 6 до 12 місяців. В деяких випадках вона є ускладненою або неможливою із-за проведення активних бойових дій в деяких регіонах України. Крім того, ми стикаємося з тим, що втрачено багато архівів паперових, і тому люди навіть не можуть знайти копії документів, які були видані особі дуже давно. Деякі з наших бенефіціарів виїхали з України без будь-яких документів, що посвідчують особу. Вони не мають ні внутрішнього паспорта, ні travel document, але можуть мати, наприклад, свідоцтво про народження, лист про захист УВКБ ООН, паспорт СРСР або проїзний документ СРСР, довідку з іноземного консульства про те, що вони є або не є громадянами відповідної держави. Тобто такі документи – це єдині документи, які мають такі особи. І тому зазначеній групі осіб має бути надана безоплатна правова допомога з метою набуття громадянства або звернення із заявою про визнання біженцем чи особою без громадянства. В свою чергу, наша правозахисна організація Right to Protection готова надати експертну підтримку у розробці належного механізму для цього в разі необхідності, а також практичну допомогу адвокатам та практикуючим юристам. На слайді є моя електронна адреса або можна звертатися на електронну адресу нашої організації rtp@rtp.org.ua. Дякую за увагу.
Слава Україні!
Слава!
Thank you very much, Julia. You can stay if you want, or no, we have Olga now for Onso. Oh, she's online, so you can stay here. Thanks a lot for this presentation. I think it's very clear, and it's very. I hope it is very useful for all of you, and I hope also that later recipient countries in Europe become more and more aware of all these problematic issues of people fleeing and with different kinds of documents or even no documents at all. So I don't know if somebody here in the audience has any question for Julia? Or we have it later, okay, good. So we can now give the floor to Olga Vorontsova-Mikhailova, who is the protection officer of UNHCR Regional Bureau for Europe. Olga, thanks a lot for joining online. You have a number of colleagues from UNHCR around here in the room. And I guess you're going to speak about the key findings of the protection profiling monitoring exercise. The floor is yours, Olga.
Thank you very much, dear hosts. Thank you, dear colleagues. I'm just a little technical remark. I need to share my screen, so thank you very much. Just let's see if this works. Please let me know if you see my screen.
So far, we're only seeing you.
Let me know if it comes up.
Not yet.
Not yet. Let me just try again. 1 second.
Yes, now it is where, yes, we see it.
Excellent. Let me try the presenter mode. Is this in the presenter mode now?
Excellent, yes.
Excellent. Thank you very much. And hello again, dear colleagues. Very glad to be with you today. You see the topic that we will be discussing on the screen, and that is the protection profiling and monitoring exercise in the context of Ukraine emergency. My name is Olga Vorontsova-Mikhailova, and I work for the UNHCR's Regional Bureau for Europe. But I'm not here alone. I'm joined by my colleague who is a data and statistics and data analysis officer. So I'm handing over to Irma for a quick presentation.
Yes. Hi, everyone. So my name is Irma, and I'm an associate statistics and data analysis officer from UNHCR, and I work together with Olga at the Regional Bureau for Europe.
Thank you, Irma. And we'll be handing over to each other in the course of this session so that you can have a change of the facilitator, but also because we really co-deliver this product together, protection and information management teams. So today we will be talking about the exercise that and it will be a little bit of an advanced information for you because UNHCR has developed some external products that are already available online in relation to this exercise, but we are also working on a more detailed analysis. So you'll have some advanced information from that more detailed analysis in our presentation today, and we hope that the actual report will be released by UNHCR quite soon and will also be publicly available. So in terms of the content, let's look at the next slide, the content of today's presentation. We will look quickly at the objectives of this exercise. Irma will talk to us about the methodology, and then we'll go through the main key findings. But before we go to that, we'll do a little scene setting because it's important, and I'm sure all of us are aware that from the onset of the Russian Federation's invasion into Ukraine, nearly 1/3 of Ukrainians have been forced to flee their homes. Nearly 7 million people are remaining displaced by the war internally within Ukraine, and the latest figures from the beginning of mid-September 2022 is that there are over 7 million refugees present across Europe and close to 4 million refugees from Ukraine that have registered for temporary protection or similar national protection schemes. And the temporary protection, as far as we know, has already been discussed in this very relevant fora with the legal practitioners today. But the protection monitoring is equally important for all of us because this is a core activity, and UNHCR values this activity very much because it carries out the systematic collection of information on the key risks, threats, barriers to enjoyment of rights, and other challenges that affect refugees, amongst other groups for which such protection monitoring exercises are conducted. And it actually helps us strengthen, promote an evidence-based protection response. So it helps us identify the needs, the primary needs that people have, identify their profiles, and therefore also help with responding to those, and also helps our advocacy with the governments and other relevant stakeholders. So the main objectives, purpose of this exercise is to understand the profiles, it's to understand the movement patterns, is to understand the priority needs, including the information needs. We will talk a little bit about that today. Also, we're looking into the situation of families with persons with specific needs and the near future intentions of persons who fled from Ukraine in terms of their near future plans. I'm handing over to Irma, who will talk to us about methodology and key findings on the respondents' profile of this exercise. Over to you, Irma.
Great. Thank you, Olga. So I will quickly provide an overview of the methodology used for this exercise. So the data was collected between May and mid-August across 7 countries in Bulgaria, Belarus, Hungary, Republic of Moldova, Poland, Romania, and Slovakia. You can see more detail regarding the sample size by country in this graph on the right side. So the total number of respondents across all countries was 23,054. And the interviews were conducted face-to-face in different locations in host countries, including border and transit areas, collective sites, and assistance points in major cities. Trained enumerators from UNHCR and partners digitally collected the data using COBA Toolbox. The respondents were identified in the selected locations and asked for their consent to be interviewed using a harmonized regional questionnaire, meaning that the same questions were asked to Ukrainian refugees across all countries. In addition, to complement our quantitative survey data, we conducted focus group discussions in Poland and Romania to gain more qualitative insights and help explain some of the patterns in the data. So we can move to the next slide. Great. So in this slide, we present key findings regarding refugee profiles. An absolute majority, 99% of respondents were citizens of Ukraine, and more than 86% of respondents were women. When looking at the household composition, 89% of all family members that left Ukraine together were women and children, as well as around 10% were older persons above 60 years old. Further, around 10% of families indicated that at least one family member has a serious medical condition, and similarly, 12% of families reported that at least one family member has a disability. In addition, among those who traveled not alone, around 5% of respondents reported traveling with unrelated children. So when looking at the socioeconomic factors, the graphs on the right side, majority of respondents were well-educated, with 49% holding a university degree and 27% tertiary or vocational education. And in addition, we asked about respondents' economic activity before leaving Ukraine, and we found that 70% of all respondents were employed, 12% were retired, and only 13% were economically not active, meaning that they indicated unemployment or housekeeping as their main activity. So I think next Olga will continue the presentation and lead you through the main findings.
Thank you very much, Irma. I hope you can hear me. I don't see the mute-unmute button, but I hope everything's well.
Yes, we can see you and we can hear you well.
Excellent. Thank you very much. So continuing with the key findings, we are coming to the actual protection analysis, and we start that protection analysis with the displacement situation. What have we seen as a result of our exercise? What we see, and what's very striking from the very beginning, is that 80% of respondents were separated from their immediate family members. And the reasons for such separation that have been cited by the respondents, there were two main reasons. One is the enactment of the martial law in Ukraine, which doesn't allow certain family members from leaving Ukraine, usually the male family members. And also the second main reason was the fact that a large percentage equally indicated that they just didn't wish to leave at the time when the other family members who were the respondents to the survey departed, or they were unable to depart for some reason, for financial, could also be other reasons. So either the martial law or an inability or unwillingness to leave. More than half of the respondents that have been interviewed were forced to leave their place of origin between end February and March 2022. So the other half, or a little bit less than half, have left Ukraine after March. So the majority of them did leave before the end of March. As you can see also from the slide, despite the fact that they had to leave some immediate family members behind, 74% were traveling accompanied, and mostly with their immediate family members. And here we are talking about this crisis as being, as it's called, gendered crisis. We have women and children, and you've seen it in the refugees profiles, a very large percentage, almost 90% of those who left were women and children. And of course, it's quite obvious that the family separation in the displacement context can exacerbate several protection risks. It can exacerbate gender-based violence, human trafficking, exploitation, isolation, trauma, just to name a few. So we need to keep this in mind, also as legal practitioners and also people of other professions that are rendering services to those that arrive to the neighboring states. Another important statistics is that not everyone has crossed the international border or didn't leave Ukraine immediately. 17% of respondents were displaced in Ukraine before leaving the country. And most of people that were displaced previously, they originated from the east of Ukraine, the north of Ukraine, or Kiev and Kiev region. So in terms of the top 10 places, you see that the main oblasts of origin on your screen on the right. The overall top 3 places were Odessa Oblast in the south, Kharkivska in the northwest, northeast, and Kiev city. Moving on to analyzing the displacement situation, we, in terms of transit, we see that the 14% of respondents transited through at least one other country before arriving to their current host country where they've been interviewed. There can be a difference. In some countries, the percentage was much higher. For example, in Bulgaria and Belarus, the large majority transited through another country, but in some countries, like for example Moldova and Hungary, the numbers were very small. And they received people that arrived primarily directly. And another interesting statistics is that 23% of respondents that were interviewed have already been back to Ukraine at least once since their initial departure for a short visit. They've returned because they've been interviewed after they've gone back to Ukraine. In terms of the documentation, the 94%, it's a highly documented population. 94% were carrying some sort of national passport, and you see the passport types on the right. The majority were actually carrying biometric passports, which allow for a greater freedom of movement within EU. And the other respondents carried internal and non-biometric international passports. The other documents that people were carrying were ID cards of some type, birth certificates, etc. What is important for us to note is that the biometric passport is a document that gives us gives people greater freedom of movement. So we need to factor that in terms of the extension of documents, in terms of receiving perhaps the biometric passports by persons who don't carry it. We heard a little bit from Julia, the previous speaker, on the fact that some people are going back to arrange for their documents. And this is something that we just need to keep in mind in terms of the access to rights to greater freedom of movement. Julia has also touched upon statelessness statistics. Just to mention that at the end of 2021, UNHCR estimated as many as 35, almost 36 persons under its statelessness mandate in Ukraine, while the government statistics is quite a bit lower. But it's also important to note that there is also a potential de facto statelessness situation amongst the Roma population, because it's believed that between 4 and 8% of the Roma community lack the civil documentation needed to acquire or confirm their Ukrainian citizenship. So we need to keep in mind the needs and the rights of the stateless persons as well, because there are different risks that they can meet when arriving or trying to return, arriving to the host countries or trying to return to Ukraine. In terms of the situation in the host country, well, firstly, maybe I will mention that the refugees, the main reasons for the refugees to arrive to the current host country where they've been interviewed was the safety the main three reasons: family ties and employment opportunities. These were the three main motivations for them to arrive to their current host country. We'll talk about intentions a little bit later, but it's kind of an important introduction for why people have arrived to the country they've been interviewed in. And in terms of the priority needs that you see on the screen, you see that cash, employment, and accommodation are the top three. But whilst cash was identified as the most common urgent need, it should be noted that the cash should really be viewed more as a modality in order to meet other basic needs. So it's likely that the need for cash, or we know that the need for cash, is strongly correlated with other urgent needs, and we have also discussed this in the focus group discussions that actually complement the exercise that we are discussing today. The questionnaires have also been complemented by the focus group discussions. So the accommodation and employment were flagged as two major and immediate needs, followed by material assistance and healthcare. And we will look at it later. There was also a priority information need that people have identified, exactly related to the urgent needs that they had. The one additional point I'd like to make on the actual employment is that, and that is related to the discussions held in the focus groups, was that women in particularly reported challenges with accessing employment due to the lack of daycare. Daycare being the kindergarten places or other childcare arrangement for the school-going children, for example, because due to the high levels of family separation and the fact that there are a lot of single female caregivers, heads of households, this is really a key issue. The childcare is a key issue that needs to be addressed for the effective inclusion into the in the host countries. In addition, the other needs that have been flagged were the in relations to the barriers to employment, where the lack of knowledge of local languages, and also persons with disabilities had issues with integrating into the labor market. Since we started talking about persons with specific needs, it's important to say that a large percentage, 23% of respondents, reported having at least one family member with specific needs. And the one that was most frequently cited, reported, was disability, so 12%, followed by family members with serious medical condition and other persons with specific protection risks. And you see older persons as well on the screen. What we concluded from the focus group discussions was that if the household has one or more persons with specific needs, it often results in the fact that the family would have fewer resources and more limited access to support networks in their host countries than the other groups. Comparing to the other groups amongst the refugee population, they may also have more limited access to information on existing services, including on health, and face limitations in accessing employment opportunities, either because they have to tend to those with special needs at home or for other reasons. And this calls to the attention of the host states, communities, to the fact that such needs need to be identified at an early stage, referred to services, support, so that they can integrate, so that we can also mitigate the protection risks and legal needs that these persons may have. Continuing on the situation in the host country, we have some data on the fact that most respondents, 67%, live in either hosting accommodation with a host or in a rented accommodation, which is of course a positive element. Other percentages you see on the screen, smaller percentages live in collective sites, reception centers, planned sites, and of course, you know, in some countries it's more common than in the others. But it's anticipated that accommodation is likely to become a pressing need as the rental costs and energy prices continue to increase in refugee hosting countries. And even among the 67 that are living in hosted or rented accommodation, the accommodation continues to be reported as a key need, which means that these arrangements may not be secure. Both rented and hosted arrangement may not be secure in a longer term. In terms of the information gathering, you would see that it's quite a highly digitalized population. So 57% of respondents have high levels of digital awareness and prefer to receive information by social media, followed by phone and websites. And in terms of the preferred digital ways of communication, Facebook, Telegram, and Viber were mentioned as the top 3 preferred digital ways of communication. That being said, around a quarter of respondents mentioned that they prefer receiving in-person information or advice from their friends and family. And this was more common with people over 60 years of age, or with those with lower levels of education that were just more interested to receive information in person or from their family and friends, comparing to other respondents. So what we can conclude from that is that we need to have a range of communication channels and formats utilized in order to reach all the people who are receiving the relevant services. Finally, our final segment is on the refugee intentions, and here it's quite visible on the screen already in terms of the near future intentions. And by that we mean the question that we are asking is, what are your immediate plans? Usually it would be the 3 months from the date of interview that we are asking the person about their plans. And the plans can be stay in the host country, return to Ukraine, move to another host country, or the person is not decided, doesn't know yet. So you see, it's quite telling from the chart that only 13% reported immediate plans, or within the next 3 months plans, return to Ukraine in the near future. But even out of this 13%, 64% were uncertain of exactly when they will do it, even though they were planning to do it within the next 3 months. In terms of their specific plans, 88% reported that they still have concerns with returning. But when they return, again, the same percentage mentioned that they would like to return or would plan to return to the same oblast that they left. And a higher proportion reported plans to return from Kyiv city. So those from Kyiv city were more likely to plan to return, 20% comparing to 13% average. And, the main reasons cited were the perceived improved situation, desire to go back home, reunite with their family members. That amongst the 13%, a bit of a worrying trend was that 22% reported that they have to return due to economic reasons or to access basic services, right? So it's really that financial situation that pushes them, or the situation with access to services that pushes them to return back. I think this is we can end on the discussion to returns to Ukraine and turn to the intentions to stay in the host country, which is the majority. You see for now, in the next 3 months, 63% are planning to stay in their current host country. And the main reasons for that are cited as safety, family ties, and employment. And families, the important finding is that families with children were generally more likely to continue staying in the host country comparing to other groups. Another interesting finding is that people staying in collective accommodation, including reception transit centers, were less likely to stay in the host country long term, and were considering either returning back to Ukraine or moving onwards. So unsettled accommodation was a reason for not choosing to stay in the host country. In terms of those that were planning to move onwards, this is, we're talking about, let's go back to we're talking about 11% here. And the reasons for moving to the next host country were, again, family ties, safety, and employment as primary reasons. And 13% out of those that were interviewed couldn't really say what were their near future intentions. They were really undecided. We have a separate product that UNHCR produces, which is intentions report that is called Lives on Hold, which we will gladly refer you to. There was an issue in July, and we will provide the link in the chat. And there are other reports that will be coming out soon, which you will be able to also access and peruse, that will include a greater number of countries that have conducted this intention surveys. So before we close, what we just wanted to leave you with a few key protection highlights that are quite important, that I've spoken about, but just wanted to repeat them before the close of this session. So family separation, 80% of respondents have been separated from immediate family members. And as we mentioned, family separation has exacerbated protection risks and existed vulnerabilities. In terms of persons with specific needs, 23% of households, almost a quarter, include at least one person at heightened risk. And such households have decreased coping capacities and need to be supported. Documentation, 7% of respondents have not carried any type of national passport, which may affect their access to rights and have impact on the possibility of return. And 25% of respondents do not hold international biometric passports, which permit greater freedom of movement. Priority needs have the main one that have been flagged were accommodation and employment. And the high levels, considering the high levels of family separation, access to adequate and affordable childcare is key to ensuring access to employment opportunities. Information provision needs related primarily to financial help, job opportunities, medical care, and legal status. So very relevant to the legal professionals in this room today. And 57% of respondents were preferring to receive the information via the social media channels, but the others have really clear preference to the more in-person information. And then finally, intentions-wise, 63% were planning to stay in their host country in the next 3 months, 13 intending to return to Ukraine, 11 planning to move to another country, and 13 remaining undecided. So these are the main findings that we wanted to share with you today. We also would like to invite you to visit the UNHCR data portal, where you can already see these figures in a consolidated format in a 4 pages fact sheet dashboard that is based on our dashboard. You're very welcome to study it, and also we look forward to exchanging with you in the questions and answers session.
Thank you very much, Olga, for this very interesting presentation and the situation of Ukrainians in Europe. And I mean, we will have more time for the questions and answers later. I think the fact that 63% of Ukrainians decide to stay, we're talking about 7 million of refugees, then you just make up the numbers of people who may want to prefer staying in Europe. So I would now like to give the floor to the 2 next speakers in the session of access to legal information and assistance to refugees for Poland. I would invite them, if you don't mind, Julia, to Malgorzata and Lorena to come here to join us in the table. I think we can add 1 chair. Okay. Yes. Finally. So I think we have a presentation. Yes. We have a presentation here, Ugo, maybe, because I think, is the one that you showed me?
It could be the one.
So Malgorzata Jaswinska, she's a member of the Warsaw Bar Association, Yes. And then, Margosata, if you want to give us some further details of yourself. Yes, perfect. Okay.
Okay, so once again, hello, thank you for the invitation. Today I would like to give you a very brief overview of the system that functions in Poland concerning the access to legal information, the assistance to refugees and migrants. So it will be more of a kind of a general presentation. And when we are talking about, sorry, can I just move that up?
I think we need to do that.
I can do that. When we are talking about the access to legal information or the access to the legal representation, we cannot forget to mention the 3 centers for legal assistance that were set up in Poland a couple of years ago. And those are places where persons with low income can obtain free of charge legal information. The legal information is provided mostly by attorneys and legal counselors and lawyers working within the NGOs. And those are centers that are located within the municipalities or at the local level, so they are pretty accessible. And here what is also important to mention is that the right to access this legal information, it does not discriminate against refugees. So it is open both to the Polish nationals as well as to foreigners. However, what I see as the greatest limitation of this system is the fact that it provides only legal information. So I can get information about my rights and my obligations, but there is no one who will be able to represent me before the authorities. So that's a bit of the drawback, especially for refugees and asylum seekers. And then another shortcoming of the system can be the fact that although the system does not discriminate against foreigners, it does not provide for the translations. So if there is a person that does not speak Polish and an attorney or a lawyer will not speak the language of that foreigner or a refugee, they will not be able to communicate, and then there will be no effective access to legal information. Okay, but then moving on to the access to legal information that is directed especially towards migrants and asylum seekers, the first procedure that has to be covered is the access to legal representation to asylum seekers. So in order to discuss that further, first we have to understand how the asylum system works in Poland. And generally it is divided into 2 phases. The first phase is the administrative phase, and there is the second phase, the court phase. We can say there are 2 instances in both administrative procedure and 2 instances in the court's procedure. And whereas in the administrative phase of the asylum procedure, the asylum seeker can submit information, can submit documents, can submit papers and other evidence in his own language. The authorities will translate that by themselves. Then when we move into the procedure before the courts, it is not the case. So before the courts, all the documentation has to be submitted in Polish, and it makes the access to the courts more difficult for asylum seekers who might not necessarily speak Polish. And then having that in mind, in Poland, the system provides for the possibility to obtain the right for legal representation. So not only legal information, but the fact that somebody will represent me within that procedure. And it covers first the procedure before the court, and then the procedure before the administrative authorities, but only before the second instance administrative authority. And what can be the problem with such a system? The main issue is the fact that the vast part of the evidence gathering, it takes place before the administrative authority of the first instance. So at this phase of the procedure, when the asylum seeker has no access to legal representation. During that phase, there is an asylum hearing. No one will prepare the asylum seeker for the hearing. No one will ask him proper questions if the authorities will forget to ask something. And that is one shortcoming of the system. And then the second limitation that I see is the fact that in order to obtain free of charge legal representation before administrative courts, I have to make the application for a free of charge lawyer in Polish. And if I do not speak Polish, then there is no one there that can actually assist me to make that request. And it leaves an asylum seeker without the actual and effective possibility to ask for that. Here you can see the main differences between the legal representation to asylum seekers that is provided before the second instance asylum authority and then before the administrative courts. I see that, at least from my perspective, the issues most relevant is the fact that when we are talking about the legal representation before asylum authorities, then the system also covers the costs of translations and of travel. When we are talking about the representation before the courts, it is not so. So what does that mean in practice? In practice, it means that if an attorney does not speak the language of an asylum seeker, they cannot actually and effectively communicate. So it leaves the system a bit flawed in that regard. And then the second, at least from my perspective, the second interesting issue is the fact that in the system of court-appointed lawyers or attorneys, it is the court or the bar that picks the attorney that will represent the asylum seeker. And that is the case when we are talking about the legal representation before administrative courts. But at that earlier level, so when we are talking about the representation before the second instance asylum authority, administrative authority, then it is the asylum seeker himself or herself that can pick a person or an NGO that he or she wants to be held by. So it is in 100% the choice of an asylum seeker as to who will represent them. And as you can see, at least in 2021, in the vast majority of cases, asylum seekers preferred to be represented by NGOs and not by attorneys or legal counselors. I suppose that the reason behind that is the fact that those are pretty much specialized NGOs, specialized in asylum law and migration law, whereas it is not always the case with the attorneys or legal counselors. Moving on to the next procedure that can concern migrants, and that is the return procedure, so the so-called deportation procedures. Here, the procedure looks very alike and is very similar as to the asylum procedure. So we also have two phases. One phase is before administrative authorities, then the second phase is before administrative courts. However, here the difference is that the whole procedure needs to be conducted only in Polish. So it is not possible for a migrant to submit documents that are not translated into Polish. If a migrant does not speak Polish himself, he will not be able to prepare by himself any kind of submission within this procedure. And here, unfortunately, the free of charge legal representation is only provided before the court, so not before this at the phase of administrative procedure. And what are the limitations of such a system? The first issue is once again the issue which concerns how the system works. So the administrative courts are the courts of law. They do not hear evidence, they do not establish facts, they only analyze whether what was done at the administrative level was correct or not. So this whole procedure and this whole phase before administrative authorities, where we actually have to submit evidence and where authorities actually establish relevant facts, it is done usually by the migrant himself, and it is the phase of the procedure where he has no possibility to obtain free of charge legal representation. And now moving on to the last procedure that I would like to briefly discuss. This is the procedure concerning the immigration detention of migrants. As you can see, maybe it's not that visible, but as you could see on the table, this is the data from 2021 from the courts deciding on the prolongation of detention of migrants. And as you can see, at least within the courts of first instance, almost 100% of requests to detain or to prolong detention of a migrant were automatically accepted by the courts, and there were in less than 0.5% of cases there was an attorney appointed. The situation is slightly better when we look at the second instance court, so there is a 13% chance that you will succeed before that court, and in 10% of cases, the migrant was appointed an attorney that could represent him or her. And here, what could be the reasons why we have such a low numbers of attorneys appointed in migration detention cases? What we have to remember is that a migrant in detention, he has the same right to request free of charge legal assistance as any Pole. So if he or she proves that he has no means to provide for legal representation himself, he should be granted legal counselor. But as we see, it is not the case. And the reason why I suppose we have such low numbers in this regard is first, the fact that the application for an attorney has to be made in Polish. If you do not speak Polish, how can you do that? If you do not have a legal representation, how can you prepare a legal submission to the court in Polish asking for an attorney and proving that you have no money to pay for that? The second, at least in my opinion, the second reason is the fact that very often those persons in detention, they are not informed that there will be a hearing in the case. So they cannot ask in advance the court to grant them an attorney at the first instance level because they did not even know that there will be a hearing in their case. And the last reason, at least in my opinion, is the fact that the migrants are not allowed to be present at the hearing. So they cannot, if they cannot write in Polish, they are not informed when the hearing will be, they are not brought to the hearing, so they have no possibility to make that request orally. And it results in a system that in practice is ineffective and inaccessible to detained migrants. And as, at least I hope that I managed to show you, we have some kind of a system that provides some form of an information, some form of a representation to migrants and refugees and asylum system seekers, but it is far from being perfect. It has a number of gaps and limitations, and for years those gaps were and are filled in by the civil society organizations, by the bar associations, by pro bono attorneys, legal counselors, that are working for the advancement of human rights of asylum seekers and migrants, and I believe that my distinguished colleagues will later discuss that in more details. And that brought us to the end of the presentation. If you have any questions, please feel free to ask them either now or later.
Thank you very much, Malgorzata, for this very realistic, though not rosy picture at all of what is the situation in Poland, and thanks a lot for your efforts and for the efforts of all those civil society organizations or attorneys and pro bono that trying to help asylum seekers here in Poland. I think we can pass on the floor to Lorena Isla Rodriguez, who is a Senior Protection Officer, UNHCR representation here in Poland. And Lorena, feel free, because we had scheduled a long coffee break, okay? So it's okay for us.
Thank you so much, colleagues, for the invitation to this seminar today. I have a short presentation. I will try to stick to the 15 minutes that were planned, but thanks for the flexibility there. And please feel free to flag if I'm going over time. So my presentation I think will be very complementary to the one that was just made, because it will focus a bit on the specific legal aid related services that are provided to those falling within the scope of the Temporary Protection Directive in Poland. But I just want to, before we go into the details of the presentation, stress that UNHCR work, of course, in Poland goes beyond those falling within the TPD directive, and that we work very closely, of course, with legal aid providers on ensuring that there is access, or trying as much as possible to support that system that my colleague has explained very well just before me. Maybe briefly to mention the UNHCR presence in Poland before 2021 was rather small. We were 7 staff, and now it has grown to over 100 staff, including field offices here in Warsaw, Lublin, Rzeszów, and Krakow, meaning at the border areas, to ensure that we support with information, identification, and referral of persons with the specific needs and basic services, but that we also are present where the majority of refugees from Ukraine are living, that is mostly in the areas around Poznan, Wrocław, Katowice, Krakow, etc., urban areas mostly. So that's to give a bit of a background to our own operational footprint. I think this has been said several times already today. The application of Temporary Protection Directive in Europe is unprecedented, and the way that the government of Poland, including the border guards, the Ministry of Interior, but definitely also civil society and just the families, the Polish families, have reacted to this. The wave of displacement it's been impressive, and it needs to be acknowledged. You can see there is 1.3 approximately million persons that have been registered for PESEL, which is to say that those 1.3 are actually granted temporary protection status in Poland, or that's how the Polish government reported. Maybe just a brief overview on what are UNHCR's key priorities here, including life-saving support for the new arrivals, which include information and legal aid, which is the main topic of our discussion today, but also targeted cash assistance, non-food items, targeted support with accommodation, emergency preparedness, because we know now that with the winter there may be additional influxes but also we have to be ready to make sure that if there are arrivals from places where there is ongoing conflict, we continue being ready, and that we are able to analyze as well the potential obstacles that they may face when trying to access Poland, or as other colleagues said, when returning, to check maybe on their properties, on their family members, and then trying to come back to a new member state. So that's definitely part of our ongoing interventions. We acknowledge that we are in a EU member state with a government that is leading the response for SORA, and our role here is to provide support to them, also with longer-term solutions and promotion of inclusion for refugees that decided to stay. For the medium term, longer term, it depends, and it's very fluid, because of course decisions on return are not easy to take, but we really want to make sure that we make the steps necessary to promote that. Then a point that I think is very important for us, the non-discriminatory approaches on asylum and protection. For us, all those who are fleeing conflict or persecution or war or persecution are persons in need of international protection within our mandate, and then we have a role to play for all of them, and to advocate and ensure that that the approaches are non-discriminatory, as I said. And then finally, strengthening community-based approaches and engaging with the diaspora. Now, on information and legal aid, I think I have the experts on the table, so it's a bit awkward, if I may, that I am the one presenting, but these are only few organizations. Of course, there are more, but for us, there are key organizations with whom we cooperate, and that have been really essential when it comes to ensuring provision of legal aid and information to refugees, those coming from Ukraine, but also others. UNHCR has a long-standing partnership with Halina Niet, the Legal Aid Center, which is based in Krakow, but has a helpline for refugees that I just pasted in the presentation. The Organization for Legal Intervention, as well, SIP, and the Helsinki Foundation, with whom we work very closely too. We have a memorandum of understanding with Warsaw Bar of Attorneys, and we are really thankful as well to some organizations that have provided pro bono legal aid support in the context of this emergency. At the beginning of the emergency, I was actually in Geneva before coming here to serve in Poland, and there was a considerable mobilization of big law firms. So we had DLA Piper, Greenberg Traurig, and others offering support with pro bono support for the emergency. In the case of Poland, as I said, I think we managed, even if still in a smaller scale, to have a pilot with European lawyers in Lesbos and Safe Passage, with whom we are providing legal aid at some of the blue dots, and I will explain now what blue dots mean. This is a map of UNHCR field offices, but also blue dots for us, and based on the experience that UNHCR had in the 2016 and onwards emergency, so the so-called Syrian emergency, we piloted an approach that was information points, basically, where persons could come and receive basic basic information and legal aid, most often not legal representation, but where they can also find child-friendly spaces, social activities, and where we can identify eventually persons that are at risk and that need referral to services, or that may be unaware of the services that are available for them and need an accompaniment. So initially, in the initial phases of the emergency, those blue dots were placed close to the cash enrollment centers. UNHCR, in the last 6 months, rolled out a considerable cash program that targeted 300,000 people. That was the way, really, for us to have access to refugees displaced from Ukraine, and to identify those who were more at risk and be able to support. And through those blue dots, we have tried to provide, as I said, information and legal aids to cover some of the ongoing needs. And these are some of the organizations that you may be aware of that are also working together on counseling, direct help and accompaniment, mentorship, training, etc. in the response to the Ukraine emergency. And I think it is fair that we acknowledge that there is a considerable mobilization from all these organizations to be able to fill those gaps that we mentioned. Now, before I run out of time, I wanted to give you just a brief overview of how the system of temporary protection applies in Poland, because it's not that straightforward. There are two main pieces of legislation that are actually relevant, and one of them is the Special Act on Assistance to Ukrainian Citizens that was passed on the 12th of March 2020. But there is also a piece in the Act on Granting Protection from 2003 that is relevant because it applies to those not falling under the scope of this Act. So the Special Act applies only to Ukrainian citizens and their spouses, but it doesn't apply to third country nationals, stateless persons, or Ukrainian citizens previously residing in Poland. It has, however, a provision that some of the Ukrainian citizens that were previously residing in Poland on other permits could have their permits extended, so they could continue residing in Poland regularly. Now, as I said, those who are not falling under the scope of the Special Act, but are falling under the scope of Article 2.1 and 2.2 of the European Commission implementing decision on the TPD, European Council, sorry, they are falling under the scope of the Act on Granting Protection to Foreigners within the territory of the Republic of Poland of 2003. This means this applies to recognized refugees and stateless persons and their family members, of course, and also permanent residents unable to return to country of origin. It, however, does not apply to asylum seekers or persons at risk of statelessness that are unable to prove that they were recognized as stateless, for example, prior to their departure in Ukraine. The two categories that I just mentioned would then be able to apply for asylum in Poland with the system that I think my colleague has explained very well before, how the system works and what are the resources available when it comes to legal aid and representation. Now, on status and documentation, I believe we have to acknowledge again that there have been steps that the government has taken to facilitate access to documentation particularly. Those who are registered for PESEL now can download an application, and with the PESEL number they will have a travel identity document that is digital and they can carry if they were to return. This is not just a travel identity document, an electronic identity document or a travel document. It is also considered a residence permit because Poland has notified the European Commission on this travel document, and this has been added to Annex 22 of the Schengen Borders Code. And therefore, it has the validity of a residence permit. In addition to that, the Special Act on Granting Protection to Ukrainians has foreseen the possibility of issuance of a residence permit that would have 3 years validity, and that has to be requested before the regional authorities, the voivodeships here in Poland. We will have to see after November how much this can be is actually effective and accessible, because the voivodeships are likely to face challenges if the 1.3 million that were registered with PESEL are actually requesting for the 3 years residence permit. That has longer validity than the actual status. As you know, the actual status goes only until 24th of August 2023, and is really subjected to the decision of the Commission on the potential extension. Now, very briefly on the return to Ukraine, because there have been questions around what happens with the status, temporary protection status, if persons return to Ukraine. The Special Act indicates that after 30 days, temporary protection status is deactivated. That doesn't mean that persons that have stayed beyond 30 days cannot return to Poland, but they will have to go through border checks, including Schengen border controls, and those who have gone beyond the 30 days at some point were issued special consents on humanitarian reasons to access the border. Right now, and thanks to this introduction of the electronic travel document, they are able to cross with the electronic travel document. They will have to reactivate their PESEL registration before the municipalities, which is possible according to the law. And of course, in practice, we see different practices, but the legal standards are the ones I just mentioned. This is the last point of my presentation. Regarding moving onwards into other member states, EU member states, there have been a lot of questions around can a person that has been granted temporary protection status or registered for PESEL move somewhere else? And if they lived somewhere else and they were granted protection somewhere else, let's say France, Germany, are they able to come back to Poland and request for temporary protection status? Of course, the EC implementing decision and the operational guidance says that before the issuance of a resident permit and within the 90 days, persons were able to freely move and decide where they would live. The Special Act does not prohibit also to settle elsewhere in another member state along the lines of the European standards. After the issuance of the residence permit, and of course this is also indicated in the operational guidance of the Commission, which was mentioned this morning by our colleagues from DG Home, they also have the right to travel to other member states, but it is important that it is indicated that the person was maybe granted temporary protection elsewhere, that this can be deactivated and the activation happens in the other member state. We heard this morning that there is already a database that is exchanging information on this. In the case of Poland, if a person that was residing in Germany, let's say, comes to Poland and requests for temporary protection status, there is a question in the form that they have to fill where they are asked to declare if they are entitled to temporary protection status and if they have already a status, so they are receiving benefits from elsewhere. And as it was mentioned in the morning, one of the key areas there is to avoid that a person would be receiving benefits in 2 EU member states. But this doesn't mean that the person would be rejected. It just needs to be deactivated in the previous member state and activated in the current one. I think I will stop there, and of course I'm happy to take questions as needed. Thank you very much again for this seminar today.
Thank you. Thank you very much, Lorena. I mean, I think there was a perfect match to Małgorzatas presentation as well. And I think that unless there's an urgent thing, I would leave it for later, for the session of questions and answers. That will follow the presentation of Magdalena Bartosiewicz. But if you want, because we have now is 3:30, so we can have the coffee break. And there is this 30-minute break. There is also our colleague Simona Gita, who's recording some of you, okay, with some testimonies, and then also that they will be later posted in the Council of Europe channels, okay? So please be aware of this. So half an hour of coffee break and chatting. Thank you. Okay, so thanks a lot for those joining online. Thanks for waiting. We were trying to get a group picture, and we just experienced it's not that easy to organize the people in the room.
Now we want Magdalena.
Okay.
And that's her presentation?
Yes, she's here or she's here or not?
Magdalena
Okay.
is online or?
And then,
No, she's here.
do we have here Magdalena? Yes. Magda, good. So we're going to start the afternoon session. We just need to stay here until, 1 hour and a half, and then we have a cocktail and we can relax again. But 1 hour and a half, I need your attention. Okay. So we are going to have now Magdalena Bartosiewicz with us. She's the coordinator of the Legal Aid Coordination Center in the Polish Bar Attorneys at Law. You may know that Poland has two councils or associations for lawyers. This is the case in some European jurisdictions. And she's going to speak about the role of grassroots initiatives of bar associations in supporting refugees in Poland in legal matters. So Magda, the floor is yours.
Thank you very much, Eva. That's a pleasure and a great honor for me to meet with all of you today. I would like to present a topic of our, let's say so, individual initiative which we took as lawyers in Poland, two bars and other legal professions. This is a Legal Aid Coordination Center. Wait a moment. Here, okay. So, Legal Aid Coordination Center is our idea. It was established in December 2021. The object of the Legal Aid Coordination Center was to coordinate the provision of legal assistance to foreigners who were victims of crisis on the Polish-Belarusian border. The center also helped people who are taking actions to resolve this crisis, and also members of local community who provided foreigners with humanitarian aid. The work of the lawyers was mainly concentrated at the point in Hajnówka. Hajnówka is a little town not far away from the eastern border of Poland. Assistance was also provided in the form of telephone on-call assistance to activists who were very active near the border and provided refugees with humanitarian aid. We operated directly at the border from 1st December 2021 until the end of February 2022. When war broke out in February 2022, it became clear to us that we had to extend the center's activities also to help refugees from Ukraine. In March 2022, a great many lawyers, bars and professions in Poland undertook a multitude of aid actions. Lawyers worked pro bono all over the country, mainly at railway stations and reception points organized by cities and local governments. They work from early morning till late night every day, including weekends, and provided refugees from Ukraine with legal information, so the information about their rights, obligation, what they can do, where they should go, what kind of applications as well they should file. Because please remember that it was those first time before the special act on assistance for Ukrainian refugees was adopted in Poland, and of course it was also the time before TPD was introduced, yes, into life, yes. So after those two first weeks, we realized that we did a lot. However, to act for a longer term, we need to structure those activities and form something like an institution and organization. What we also realized is that we should join our forces as all legal professions in Poland, and we do it. We started to act together under the name Lawyers for Ukraine, so in Polish, Prawnicy Ukrainie. After those first 2 weeks, we also realized how much help the people coming to Poland needed from us, what issues they were mainly asking for, and also what issues needed to be covered by us if we want to help them, not only for first 2 weeks, but also for long term. We also wanted to relieve our colleagues who were involved in helping refugees in reception points. So we thought that we needed to move the help online as well, and as try to focus on other channels, for example, internet. Of course, this kind of help was considered by us at the beginning as an additional one, because face-to-face advice was still put on the first place by us. However, we knew then that we should focus also on online actions. In mid-March, we opened an office for Center for Coordination of Legal Aid in Warsaw. We also received support from business entities. For example, when we decided to open a helpline, Deloitte, so one of the big 4 companies, provided us with the use of a modern call center platform, totally free of charge. Actually, we still work on it, and we are free to work at least until the end of this year. So we started to use this platform and organize this helpline. You can see on the slide the number of this helpline is still active. Legal information was provided then by volunteers, Polish attorneys at law and advocates, and then as a result of need to know the Ukrainian and Russian languages, we also started to cooperate with Ukrainian lawyers who actually are also refugees because they fled to Poland because of war. We have trained Ukrainian lawyers in Polish refugee and migration law, also on the special law on assistance for for persons from Ukraine. The helpline operates in 4 languages, so it is of course Ukrainian, it is Polish, it is Russian, and it is English. We have also organized financial support for Ukrainian lawyers who have started to work for our center, because it is also important for us to support them here and make their lives possible. We didn't want to ask them for work pro bono, bearing in mind this situation. So, as you can guess, of course, our legal profession is not very graceful if it comes to immigration. That's why we decided to support our colleagues from Ukrainian Bar Association. As you can see on the slide, there are currently 14 Ukrainian lawyers working for our center. 8 of them work in Warsaw, 4 in Lublin, and 2 in Wrocław. So statistics from May to mid-September show that consultants carry out a total of 1,200 to 1,500 consultations per month within the helpline only. So I think that this is a quite great number. The consultations cover the following issues. So, for example, legal status of Ukrainian nationals arriving to Poland, legalization of stay and work of foreigners, also those people who entered Poland before 24th February, so they are not covered by the temporary protection directive provisions. This is also temporary care and family foster care for unaccompanied minors of Ukrainian citizens. At least at the beginning of war, there are a lot of this kind of situations, so it was an issue in Poland. Helpline covers also employment of Ukrainian nationals, so the special law and the labor codes, Polish ones, of course. And as well access to essential services such as education, social benefits, also employers' obligation. So as you can see, mainly topics mainly concerning livelihood issues. Of course, as time goes by, those issues are more and more complicated. That's why we Polish lawyers, we still supervise our Ukrainian colleagues. I don't want to make it sound bad. However, as you know, it's not easy for Ukrainian lawyers to enter Polish law without any problems. So still, we need to supervise their work and train them. So of course, we do it. And of course, we focus as well on internet. So in March 2022, we launched a website of centers. So the website provided essential information for refugees, as you can see on the slide, frequently asked questions, legal aid points throughout Poland, as well as information on legal assistance that foreign lawyers as well were willing to provide in their home countries to Ukrainian refugees. The website was also available in 4 languages. It was created for us as a support from private entities who wanted to join in helping Ukrainian refugees. At the start of the war, the site averaged around from 1,500 people to even 2,000 visitors per month. So it was also a great number. In June 2022, we also signed the agreement with Wolters Kluwer Polska. This is one of the largest legal and economic publishing house in Poland. Among other things, Wolters provides us with up-to-date content to websites, so advice, studies, manuals, all of the information refugees need to know. Of course, everything free to publish on the website, so we don't have to pay for this either. A real breakthrough in the development of the center was the Norwegian Refugee Council's interest in this initiative. The organization decided to enter into cooperation with us in June 2022. Thanks to the support of this organization, the further development of our helpline and legal information website became possible. The current project we are running together is planned until the end of this year, but of course with possibility of extension. NRC has helped us to further structure our activities and plan for a longer term. The NRC's experience is invaluable for us, and their help is crucial. I think that our grassroots project, thanks to them, is able to grow. So our help, which we provide, is reaching more and more people who need it. In September 2022, we opened also a new professional website. So this address, which you can see on the slide, is a present one. So please, if you visit, click on this address. The website contains the information available so far and current updates. In addition, the website is enhanced with a chatbot that refugees will be able to use. We decided to change the layout and design of the site due to make it more user-friendly. The chatbot is also available on this website, as I mentioned, and we thought that this chatbot could be very useful for persons who, for example, they are traumatized, they don't want to talk about the legal problems. Maybe for them it's easier to just, have a chat, yes, with a consultant. So I think that this is a good idea. We will see how it will look like. Within the project, we will also organize a program of trainings in the basics of Polish law for Ukrainian lawyers, also refugees, not only our consultants, but the larger group of lawyers. Those persons, together with Polish lawyers, will help their fellow citizens in solving legal problems. Some of them are in Ukraine, but some of them are in Poland. So I think that those lawyers who are still in Ukraine could be very helpful for their fellow citizens who, for example, thinking about leaving. And maybe they could also provide them with information about the current legal situation in Poland and possibilities to act. Before 1st October, we will also launch an awareness campaign to spread the information about our helpline and new website address. We are keen to ensure that our aid reaches as many beneficiaries as possible. The campaign will be based on the internet channels, but we will also promote information in places frequented by Ukrainian refugees, for example, local governments, offices, and humanitarian aid sites. As part of the project and in cooperation with NRC, we also coordinate pro bono individual legal assistance for refugees whose cases are so complex that this phone consultation is not enough to solve and to help. So our attorneys and advocates can represent the refugees before courts and before administrative authorities. Such cases are handled by the group of Polish lawyers who provide such assistance. They are, of course, experienced in the cases that refugees most often report to us. The NRC grant also allows Polish lawyers to provide assistance to refugees who are victims of the Polish-Belarusian border crisis. This is an additional benefit of the cooperation with NRC because we must not forget about those people, because I have sometimes the impression that everyone talks about Ukrainian refugees, but please remember still about the people from the Polish-Belarusian border. They are still here, sorry, and we need to help them. So we are very grateful that NRC understands it and supports us in this initiative. Oh, and here I would like to present you all of the partners of our initiative. In the courses of a few months, on the initiative of a group of people, a big thing was created, supported by a large number of actors, as you can see. It is very important not to forget about this impact and to encourage more and more people to participate. I think that this is a very good example of how a grassroots project can make a great impact and help many people. So, thank you very much for your attention. If you have any more questions, please feel free to ask. You can see on the slide the email address of our center. So, of course, please contact us also by email in case of any need. If I can ask, I would like to ask you to share this information about our center with your colleagues, also on the website of your organization. We'll be very grateful because we would like to share this information with as many beneficiaries as possible. And what I can else add, we will be here as long as our help is needed. Thank you very much.
Thank you, Magda. And apart from recognizing your contribution with this presentation, I would also like to thank you for being a key actor behind the next launch of the Council of Europe UNHCR help course on asylum and human rights that will take place here in Warsaw on the 20th October. That also my colleague Olga Kostenko will attend. We have now planned a session of questions and answers. We have had a lot of interventions from Julia Chervatiuk, from Olga, Vorontsova, Mikhailova, Malgorzata, Josvinka, Lorena, Isla Rodriguez, Magdalena now. And I would like you to start this session and then to address your question or comments that you may have. Okay, thank you, Alessio. If there are not too many questions, I will point people randomly, so be ready, okay, and be attentive. So, Alessio, thanks for breaking the ice.
So my question is for the protection officer for the UNHCR regional office in Europe. and because I was really interested in the figures that she presented, particularly when it came to the intentions of displaced people to remain in the host country, because it strictly links as well with one of the challenges I was highlighting this morning. As I was mentioning, in Italy, one of the questions that arise from Ukrainian clients is how they can remain in Italy or elsewhere in Europe in the long run. So I think this is an important topic to be developed, even though it doesn't particularly, I mean, it goes beyond the temporary protection, but I think it's something that is worth mentioning and deepening from the perspective of legal professionals. And I would like to know what is the idea and of you know, UNHCR, but also European Commission, because temporary protection in theory is supposed to end in March, probably is going to be extended, but how are we going to address the need of these people that wants to remain in our countries as a legal professional? Thank you.
Thank you, Alessio. I will give the floor immediately to Lorena. It's like, Olga, you can sit here if you want also. Okay. So, Lorena.
I don't know if Olga is online, because I think the
Yes,
question. Yeah, okay. So I'll let Olga first come in, and then if there is Anita, I will complement.
Thank you very much, Lorena. And thank you, Alessio, for your question. Very, very pertinent as well. What I'd like to note, unfortunately, we are not online, in person, rather, with you today. We're online. But what we've done, and maybe the organizers can share it with all the participants, is we've shared the latest report that was released just last Friday. That is the actual report that focuses on intentions. It's called Lives on Hold report, and it's a second in a row that has been released and that talks about intentions in a little bit more detail. So there, of course, what I need to underline is when I mention the interim findings that are relating to the protection monitoring exercise, there we really talk about the near future intentions, right? I mentioned the 3 months, you know, and this is really the quite a high figure of the stay or preference for stay in the host country of origin relates to the near future intentions. Meanwhile, the more longer term intentions are also indicated in the report that I'm referring to, Lives on Hold. And there is difference. 81% of the respondents to the intentions reports in the countries that are, some of the countries are the same, some of the countries are additional in this report. They're covering a broader range of countries. But in the longer term, 81% of respondents would like to return back to Ukraine. But of course, they're looking at the conditions of return, and this is the main reasons for that, or the main lackmus paper for them, if we can say so. I can read it out for you. The main impediment to return reported by refugees is the safety and security situation in places of origin, along with concerns about lack of access to basic services and adequate living conditions. So it's about addressing these root causes of the fears of people to return in the near future, but overall, 81% of persons interviewed would like to return to Ukraine. So in that sense, it will be quite a different picture from what we see in the responses with regard to the near future. The big question, the million dollar question that you're asking is, of course, how can we prepare for that? Indeed, it's a very important question, and UNHCR is working with the partners at the country operation level, also the central level, to plan for that. Of course, we had a discussion on the TPD earlier today, and there are conditions for extension depending on how the situation develops. But just to reinforce the fact that indeed this is something that we can probably not respond to in a very short way in this question and answer session, but it's definitely something we need to look out for, and we need to keep in mind the immediate intentions and the longer term intentions of the population that we're looking at. I hope this responds to some degree. I'm handing over to Lorena for in case she has any additions.
Thank you so much, Olga. And thanks for the question as well, which is not an easy one. I will maybe focus on Poland because that's the one I represent. I think considering those survey results, we could foresee that for sure there is a considerable percentage of persons that are likely to stay beyond March or beyond August, because temporary protection in Poland goes until August 2023 here in the host country. Fortunately, I think, and I hope this will remain, there is still in the Special Act the possibility of requesting for a residence permit that goes up to 3 years. That's at least a solution in the midterm that we welcome and that we'll have to support for those who are willing to stay. A question that goes a bit beyond that is what happens after the 3 years, or what happens in the period that they will apply maybe for residence permit and until this is issued in terms of access to services and rights. And of course, for us, the last resort, in a way, is always the asylum system. But we all know that the asylum system has been, unfortunately, unable to process and manage the numbers that have been managed with this refugee emergency and with thanks to the application of temporary protection. So when we go back to how asylum system could process better, UNHCR has a very clear position issued in 2017, fair and fast procedures, and a most recent one as well on the practical application of all the procedures, which are available and are just our reference point when it comes to how to ensure that those who are in need of international protection, should the temporary protection directive that don't apply in the future, could access temporary protection effectively. Could access international protection effectively. And that's, I think, all from my side.
Thank you, Olga and Lorena. I guess that Alessio is not fully satisfied because of course, all the uncertainties surrounding, first of all, the war, and then how everything will develop in Europe. There are also, we're discussing a lot of technical issues of things that depend on the national authorities, but on this, allow me to say that in a way, the Polish authorities are kind of visionary, or maybe more realistic, or maybe anticipating that, or they anticipated earlier than others, that this war may last longer, as it is now the case. But there is also a lot of things that depend also on, I guess, political decisions at European Union level, and that's why it was very important to have you also today with our interlocutors in the EU, so that they can push from their positions also to advance the right political decision in due time. So somebody else? Otherwise, we're going to also start introducing ourselves, because before the cocktail, we should know who we are. Many of us here on this side of the table, we have already spoken, but some of you here, not yet. So, but yes.
I have maybe some question to Lorena, because you opened the issue regarding the restrictions from the Poland in particular, but I know that there's more or less same rules within the whole European Union regarding the persons who exit with the temporary protection, and there are some terms for how long the person can exit. And you mentioned that in case it's up to 1 month, so the pencil will be restored. But if this is over 1 month, are we talking about some special additional procedures, or it will be asylum procedures? So what are the alternatives after 1 month period? Thank you.
Thank you so much for that question, and I think I went a bit fast through the presentation, so it was not very clear. What the Special Act says, and there are many Polish lawyers in the room, so I'm sure that they can relate to that better than I do, but I will try to explain. The Special Act says that after 30 days, if the person has stayed outside Poland, their status is deactivated. However, there is the possibility to reactivate the temporary protection status if the person asks for it at the border point, or if they go back to the municipality and request kind of to get also the vessel reactivated. That's what the Act says, that even if the person has stayed beyond 30 days outside Poland, they should have a possibility to reactivate their temporary protection status. That's also what we understand that the Commission has advised Member States in their operational guidance and in the different exchanges. How this applies in practice, I think we have to acknowledge that there have been instances where persons were coming after staying beyond the 30 days and facing difficulties to enter back to Poland. The government has said that thanks to DIA, PL, that was the application that I mentioned, the electronic document, that should have reduced by now. So the obstacles that some people were facing at the border should be something that has been overcome. But it has been mentioned by legal aid providers as well that families traveling with children under 13 are worried because children under 13 are not entitled to the electronic travel document or the identity document. And therefore, they are not 100% sure that if they come back at the border, they will not face difficulties. Again, last resort, there was this possibility of granting a special consent, 15 days, and the person is able to access on humanitarian grounds. But I think the issue is that there is still certain level of uncertainty for some families, regardless of the fact that the law foresees the possibility of having that status reactivated. I hope I addressed this one.
Lorena, if I may, additional question to this. Okay, but we just heard that Cecilia said that in general, people can live to up to 60 days. Why it is the case for Poland to reduce it to 30 days, and why there is no conformity between all member states? I mean, what is the rule?
Thank you so much. I think that question should be made to the government, which is not represented, I think, in this room. But it's a very good point. So I think there is already an analysis on alignment to EU standards that is online. So maybe colleagues in the room, if you want to add. But there are few areas where the Special Act goes beyond the standards that the Commission and the Council have implemented, and some areas where we would advocate for sure for longer periods to avoid the activation, immediate deactivation after 30 days, because that creates obstacles at the border still, regardless if it has been really improved with this electronic document. So I think at the regional level, actually, UNHCR is advocating for that to avoid the activation because of the reasons that I just explained. And the Special Act has been changed many times in Poland, so we don't know. There may be changes coming, but not sure that a specific section will be covered in these changes. But thanks for raising that.
Any more questions? Or we start to also introduce ourselves, starting by the lady in white behind. Nora, just to say who you are, yes, to introduce yourself before the cocktail, so that we know you, okay?
Ай. А можна українською? Чудово. Я юрист з України, мене звуть Юлія Марець. Вибачте, просто дуже скучаю за українською мовою, я її просто обожнюю, кохаю донестями, тому хочу звернутися до української до вас. Я релокувалася, звісно, через військову агресію Російської Федерації в Україні. в Братиславу, тому зараз перебуваю там, працюю в юридичній компанії. Хочу сказати, що мені дуже близька ця тема через те, що свого часу наша адвокатська компанія також допомагала українським біженцям, які потребували в тому числі юридичну допомогу. Це означає, що це особливий тип клієнтів, тому що юридичні послуги не були їхнім пріоритетом, але це було те, чого вони не могли уникнути, на жаль. І я розумію, знову ж таки, всі проблеми, які були обговорені сьогодні. І це дійсно проблема праці українських юристів на території Європейського Союзу, їхньої адаптації, вивчення законів. Я це все відчула, власне, на власній шкірі, як то кажуть, тому що ми зобов'язані допомагати своїй країні, наскільки ми можемо, і так, як ми вміємо. І ми зобов'язані швидко вчити мову, ми зобов'язані швидко вчити чужі закони і роз'яснювати їх тим, хто це потребує. Тому дуже тішуся з нашої сьогоднішньої зустрічі, вельми вдячна всім, хто до цього приєднався, тому що попри інші надважливі потреби, з якими стикаються люди, юридична сфера є те, від чого, на жаль, ми не можемо відректись, наскільки би це, можливо, нам не подобалося, і хотілося б від цього абстрагуватись звичайній людині, яка не юрист. Адже кожен, хто телефонував, а в Братиславі, в Словаччині в тому числі, українських біженців теж досить багато, і кожен з них потребує допомоги поміж всіх тих юридичних труднощей, колізій в законодавстві, проблем. Кожен телефонував з проблемою людською, і кожна юридична консультація закінчувалася плачем. Тому дійсно дуже вдячна тим, хто прикладає всі зусилля. Дякую кожному з вас, хто допомагає Україні, тому що нам це зараз дуже важливо, дуже важливо. Тому ще раз вдячна всім присутнім. Слава Україні!
Well, thank you. Thank you very much. That's why I thought it was a good idea to have you. And also, you raised a very important point. Before Philip presents himself, I wanted to say something that may be useful for so many Ukrainian lawyers or legal professionals that are relocated in other countries. You can always access, if you want, some of these help courses that we have on various human rights issues, but not just think of human rights per se, but on topics like privacy rights, like cybercrime, like international cooperation in criminal matters, asylum, everything. You have the corruption, you have it. As I said, we are close to have half of the catalog translated into Ukraine, but we also have many of these courses translated into the national language of any given country and with complementary information of this given country. So, for instance, lawyers, Ukrainian lawyers that at some point decide to stay here in Poland and to stay longer and want to practice their Polish legal terminology, because it's very important to master the legal terminology of a country. I'm from Spain. Sometimes when I have volunteered to make translations of legal things in Spain, it's very difficult. I cannot do it right away. So it's very important to master this. So you can use these help courses to practice not just your linguistic skill, but your legal terminology, and to become, if you were like a data protection lawyer in Ukraine, back in Ukraine, and you are now in Italy, or in France, or in Austria, you can later check this course in French, in German, so you can see how it is in the country, okay? So, and thanks a lot for your contribution. Philip?
Sorry, now it's better. So Filip Czernicki once again. I'm with the Warsaw Bar Association of Attorneys at Law. I'm pro bono coordinator for the Bar Association, and I'm also running the coordinating program of legal advices that are provided to Ukrainian refugees at those reception centers. That's organized by ELIL, that's the NGO called European Lawyers on Lesbos. So it was set up when there was the crisis, and it's still there, which is also important to mention. So we still have the ELIL is still there on Lesbos. So we are here also coordinating a number of lawyers who are volunteering from they mostly coming from big law firms. So they exchange every week or every 2 weeks, being then present for this week or two at one of those reception centers where Ukrainian refugees live, or at Blue Dots organized by UNHCR, so in Warsaw. It's a huge demand on that help. We served so far during this past 2 months something like 600 people, and with a huge variety of cases dealing with from like everyday problems to war crime victims. So really there is still I'm mentioning this in detail because what I experienced was kind of a surprise that there were lawyers and there were NGOs, both in TAC Expo, in Nadarzyn, in Modlinska, another big expo center where there are more than 1,000 people still living, and there were lawyers and they are gone. So I mean, so when we entered the place, there was a huge demand for legal advice, of pro bono legal advice, as those who were providing this help originally didn't manage to continue. So our goal is to broaden the scope and try to involve as many pro bono lawyers as possible. So for now we have scheduled the program for 3 months, but we are extending it now for another 3 months, and also inviting more law firms to contribute. So we hope that this will continue as long as it's needed. So that's the ultimate goal, so that there is no single person not served, so that we really are there as long as the refugees are there. Thank you.
Thank you, Filip. The gentleman next.
Thank you very much. My name is Helmut Blum. I'm coming from Austria. I have a private law firm in Linz, Austria. I'm specialized on human rights law and migration law, and I'm also a member of the CCPE committee, migration committee. I have not very much experience with refugees from the Ukraine, which might be following the fact that things are going quite well in Austria. So the problems are not very, very difficult for the people coming from the Ukraine in Austria. I've learned a lot today. I was very glad to be here. Thank you for this wonderful seminar. And I hope the war will end soon and everything will come back to a normal way. What I'm a little bit afraid of in Austria is that we have limited this temporary protection for 1 year. And we will see what happens next year, March. I think they will extend it for another year, but there is no way to get a residency permit in Austria for the people coming from Ukraine so far. And our government is very strict in this way, and I hope we will find a solution for those people who really want to stay in Austria for a longer period of time. Thank you very much.
Thank you very much. Since Delphine will speak later, maybe we can jump this to this side of the room. Yes.
Hello, my name is Alexandra Pustova. I represent here Foundation Our Choice. It's Ukrainian house in Warsaw. And I'm a coordinator of helpline and consultation point in Ukrainian house. Thank you very much for this seminar. It's a lot of useful information for us.
My name is Oksana Pestrakova. I'm also from Our Choice Foundation, and I'm also a coordinator of consultation point and helpline. And I would say briefly, I would like to say briefly about our organization. Our Choice Foundation was founded in 14 years ago, and it was an organization created by migrants for migrants to help them. And also, after the beginning of the war, our organization is it actually still growing. And the main fields of our activity is also legalization, because we try to provide information about the legal state, about the legal job and so on, because it's very important to provide people with this information, because if you're new in this country, you want to do everything correct. So, and from the beginning of the war, we get a lot of questions about PESEL, about 90 days in May and June, I think it was at that time. And now also our, I think, the most often questions DAPL, and we are also waiting for the questions about residence permit in October and November. Thank you.
Hi everybody, my name is Jarmila Karakvarkova. I'm representing here OPU organization for the aid for refugees from Czech Republic. Our organization is an NGO which provides aid to refugees for many years. Nowadays, we just spread our activities also for or people fleeing Ukraine. On daily basis, we really met people who deal with problems with legislative, not like personal problems as a person fleeing from war, but also with the legislation problems. And now it's quite nice to see that there are many similar challenges throughout the Europe, like long-term solutions, like family reunifications, I don't know, like bringing together family members to whom the protection was granted, but by different countries. So this is something which has to be solved for the future. What concerns Czech Republic, now the temporary protection is granted till March, but it should be prolonged. Now it's in the procedure of amendment of the laws, focusing on the Ukrainian refugees. So we hope that also we are also waiting for, as I said, those long-term possibilities of stay in Czech Republic, however, is questionable. So we will see in the future. It's nice to be here. Thank you for being invited. And looking forward to the future and to new things which will come, hopefully, which will make the life of those people in our countries easier and like better to know or focus on the future, not to stay in uncertainty. Right now, they don't know what will be with them in the future, which is, I guess, the main challenge and the main question for them.
Thank you. You can pass the floor maybe to Derisava and you. Yes.
Hello, my name is Anastasia Zernova. I'm from Ukraine. I am a lawyer. Right now I live in Vienna, and I can share my experience of integration in Austrian society. Really, it's very hard to integrate because of strict of laws, and everything is limited. Really, for me, everything is limited, but I try to integrate, try to study language, but in the case, what problems what we will have for like refugees, it's about education. In Austria, all kids have opportunity to go to school only till 15. And what will be with another children? How to protect their right of education? They will go to work, but in Ukraine they have opportunity to study more, 1 year. That's why it will be a big problem, and right now it's is a problem for children after 15 years old. It's according to the Austrian legislation. What about women and protect their rights? Really, Austrian government try to do everything what they can do, and we feel it. Of course, everything depends on the federal lands, because we know the structure of the state. But I live in Vienna, and I really appreciate everything what Vienna do for women. I participate in one big program, Compass 100, for immigrants, for women who immigrate from different countries right now. And it's really a great opportunity to integrate on the labor market. That's why they try to do everything. What will be the problem in the March? What our colleagues said, what will be with our status? And we cannot wait during the March. It must be decided more earlier, I think maybe in November. About protection with the men. It's really the situation. We talk about women every time, but we forgot about men who stay with kids. And I know such cases when a wife died in Austria and he stayed with 2 kids. And really he must move from Ukraine to kids to Vienna because with whom will stay kids? And we should analyze such cases too. And of course, we know that all Ukrainians have to work in the European Union and pay taxes. What will be with this situation? And all countries make their own decisions according to their legislation, but we hope that it will be not so strict to Ukrainians who have a temporary status in right now. I really appreciate your event. Thank you for sharing your experience, and I think in the future we will help you too. Thanks.
Hello, my name is Olga Vavrenchuk. I'm a lawyer in Kyiv Bar Association, and I was recently admitted in Strasbourg Bar Association. I have as well a question about a case when a father, one of parents, normally it is a father, don't agree that kids stay in Europe, like a temporary protection. What will be in this case, because father or mother, if it's both of parents, it's not agree about a usually state of kids. It means it is state in Ukraine before the war, or we can admit it is a state of temporary protection.
Well, thank you, Olga, for raising this. It's a very complicated thing. It is regardless of the war. What happens with parents that are residing? In this case, we speak of main cases, I think, Ukrainians, but they are residing in 2 different countries, and what happens? Actually, it's a very complicated situation. This is family law as well. And, well, actually, we have a help course on family law. There is the Hague Convention that regulates, but it's not an easy thing, even when it's not war. So imagine now, but definitely it's something that has to be addressed. And I think that I don't know the exact details, but my instincts would tell me that what the Ukrainian legislation would say, if one single parent can decide over the fate of their kids, maybe could be acknowledged by the national authorities. But I do not know what the Ukrainian law says. And this is just the easy, instinctively solution I can venture.
I have to acknowledge I'm not an expert in international private law, and I think that there are components there that are linked to that. So when it comes to international refugee law, that is what we are more familiar with, of course, colleagues this morning from DG Home and others have said what would be the principles applying for unaccompanied or separated children that needs to travel out of Ukraine and then be reunified with parents that maybe live elsewhere. Of course, they are covered by the Temporary Protection Directive, and their parents could choose where they receive protection in Europe, so there is no Dublin application. Now, issues relating to parents not agreeing on where the children should live is a custody-related issue, right? And then you have, then I'm entering in an area that I'm not 100% familiar, that is, what is the jurisdiction that applies, is where the children reside, where the parents reside, and then if there is a disagreement, it's very often that then you have to go through court procedures, right, to decide on the best interest of the child. That should be the principle that, sorry for maybe not addressing fully, but yeah.
Continue with close to...
Yeah, hello again. My name is Evgenia Bulgakova. I represent the 10th of April, which is a UNHCR implementing partner in southern regions of Ukraine. We cover the assistance to asylum seekers and refugees, IDPs in Ukraine, and stateless persons. I personally hold the position of project manager for asylum seekers and refugees. Of course, for objective reasons, it's seriously reduced. Also, currently I'm holding the position of head of the legal department covering the protection for IDPs, legal protection. Of course, we do not stop just at direct legal assistance. We also work on advocacy issues, so we advocate for the rights of asylum seekers, IDPs, stateless, all the persons of concern that we work with. And within the IDPs issue, we also provide humanitarian assistance, social assistance, psychological assistance. The same for refugee issue. We cover all the types of protection for refugees and asylum seekers that are currently continue to stay in Ukraine. Thank you.
Мене звати Зейтулаєва Ельвіра. Я юрист, старший юрист громадської організації 10 квітня, яка є партнером, виконавчим партнером управління Верховного комісара у справах біженців. Ну, Женя досить много сказала про нашу працю, але я тільки можу додати те, що я вже вдруге стала ВПО, тому що в 2014 році я проживала у Криму, у місті Сімферополь, і коли російський агресор анексував Крим, я з дітьми вимушена була приїхати до України, материкової частини України, і працюю в 10 квітня з 2015 року старшим юристом.
Hello everyone, my name is Shakhsnia Rustemova and I am a lawyer in right to protection. During my very short working experience, I had a chance to work as a consultant to asylum seekers in Ukraine, and after the beginning of full-scale war, I had a chance to provide legal consultations to IDPs, and right now I'm working with asylum seekers who were registered in Ukraine, but due to the war, were forced to flee Ukraine to European countries. So basically we are conducting deep research on what Yulia has already mentioned, what documents host countries usually require from asylum seekers, because not everyone has travel documents or anything. So
Доброго дня. Я буду говорити українською з вашого дозволу. Мене звати Юрець Олена. Я юрист з України, з Києва. Наразі в перші дні війни ми переїхали з дітьми, з родиною ми переїхали до Словаччини, до Братислави і маємо тимчасовий притулок саме там. Я продовжую працювати в Україні в своїй юридичній фірмі віддалено. Ми працюємо над питаннями відновлення, над питаннями інвестицій, релокація бізнесу, як би це не звучало дивно, але ми вже зараз починаємо працювати над тим, щоб можна було якшвидше відновити Україну у разі нашої перемоги, в що ми, звичайно, дуже віримо і віримо в те, що це буде якомога швидше. В той же час, завдяки Словацькій асоціації в Братиславі, я співпрацювала з асоціацією, надаючи, і наразі продовжую співпрацювати, надаючи допомогу українським біженцям. Ця співпраця полягає у тому, що я надаю консультації як письмові, так і усні, тому що є дуже багато запитів, навіть і на сьогоднішній день. Я думаю, що по кількості біженців Словаччина, мабуть, на другому місці після Польщі. Дуже кордони наші межують і багато хто релокувався саме в Словаччину. Звичайно, всі питання дуже часто такими, як хвилями. Спочатку хвиля питань була про 90 днів. На сьогоднішній день хвиля питань про 183 дні і про подвійне оподаткування. Виникли останнім часом дуже багато питань стосовно, як підтвердити кваліфікацію. Я маю на увазі не лише юристів, медики, архітектори, ті, хто хочуть працювати, у них виникли технічні питання, як ліцензії їхні можна адаптувати. Сама держава, звичайно, не проти. Сама держава підтримує ініціативу українців продовжувати професійну діяльність. Але, звичайно, законодавство було не готове і дуже багато змін потребує внесення саме на законодавчому рівні. Тому для мене, як я сказала, я працюю і працювала з інвестиціями. Це великі проекти. І спочатку, звичайно, мені здавалося, от українець з якимось таким звичайним маленьким питанням, маленьке питання. Але коли потім починаєш розуміти, що для людини це насправді питання життя і смерті, це питання вибору, це питання прийняти зараз рішення, тому що воно реально впливає на твоє майбутнє. Це або ти починаєш нове життя, або ти повертаєшся в Україну, і кожне це рішення залежить від регулювання. Тому я дуже здивована, мені здавалося, що ці питання, вони важливі для мене, для того українця, який звертається, і для Словацької асоціації адвокатів, тому що вона мене залучила. Я дуже приємно сьогодні здивована, що така велика кількість людей залучена в цей процес, що так багато людей намагаються допомогти українцям, намагаються вирішити наші проблеми спільно, і цей захід є дуже важливим для всіх нас, особливо для юристів, які співпрацюють з біженцями, тому що багато сьогодні я для себе почула відповідей на питання, які я можу ретранслювати далі біженцям, українцям, які звертаються. Багато відповідей знайшла для себе, і як рекомендація чи, можливо, прохання, то, звичайно, прошу звернути увагу на це питання стосовно подвійного оподаткування, тому що, по-перше, для України це дуже важливо. Якщо податки будуть сплачуватися в країнах Європи, то український бюджет дуже багато втрачає. 7 мільйонів людей виїхало, відповідно, податки, які б вони платили в український бюджет, виїхали разом з ними. Тому для України з економічної точки зору це важливо. Я знаю, що готуються ініціативи зі сторони України, щоб якось вирішити це питання. І було б дуже правильно і доречно, якби і Європейський Союз зі своєї сторони підтримав такі ініціативи і уникли цього подвійного оподаткування. Дякую вам за захід і дуже рада, що ви продовжуєте, я так розумію, ще й посилено на майбутнє плануєте продовжувати таку допомогу, і спасибі.
Доброго дня, мене звуть Кадуліна Інга, я також з України, з міста Запоріжжя. Я практикуючий адвокат. До війни у мене було більш кримінальних проваджень. Зараз я також продовжую працювати в Україні онлайн, беру участь у судових засіданнях. У Словаччині я також беру участь у стажуванні у словацького адвоката. Ця можливість нам була надана завдяки зусиллям словацької колегії адвокатів. Ми досить часто спілкуємося, зустрічаємося, у нас існують спільні теми для подальшого, скажімо так, для подальшої співпраці. Я підтримую дуже ініціативу щодо започаткування не лише у Польщі, а й у Словаччині центрів з надання правової допомоги безкоштовної. Ми знаємо, адвокати з України, ми знаємо, що у нас ця система дуже розвинута. Я також беру участь і працюю за контрактом і у цієї системі. Це дуже інтересно і це, звісно, надає нам, адвокатам, можливість брати участь у наданні правової допомоги про боно. Я дуже вам всім вдячна. Я навіть можу сказати, що я щаслива, що я приймаю участь у цьому заході. Дякую вам.
Good evening, everyone. My name is Natalia, and I'm also working with Julia and Shakhsnay in the right to protection. I'm a legal analyst in right to protection, and I also work with a project which concern third national countries which fled Ukraine after the 24th of February. Yes, Julia already mentioned the problem with recognition of documents, but I also would like to cover shortly that the non-recognition of the CP documents influence on the integration into society because it is difficult for Ukrainians to integrate to European society, but for those who second time were displaced, it's much difficult to integrate because of delays, because of different obstacles with employment, bank registration, medical and social service, and so on and so on. So yes, we are preparing with Hayas the report, which will be issued, I guess, in December, January. We will also present the problems, difficulties, and recommendations addressing these issues. Okay, thank you for the event and for information.
Okay, so thank you very much. Well, Hugo, who is holding the microphone, is helping us organizing all this event. And there is also Volodymyr somewhere who other. Yes, I think that if you want, we can pass on to the last session, the conclusions, unless there are any questions, I think no. So we move on to these conclusions. I'm not sure if Cecilia is online or because she may not have, yes, she may not be online. No, she's not, yes, okay. In any case, she already excused herself, so Delphine, we will change your title and then we will leave you the floor. It's fine, okay? So I will, well, Delphine, sorry, because we are working together in Strasbourg, and I forgot to introduce her. So she's the legal associate of the UNHCR representation to the European institutions in Strasbourg, and I'm happy you came here. Sometimes it's better to find us elsewhere rather than on the corridor, because Delphine is quite busy. It's a very small but very active and very important representation of UNHCR. So Delphine.
Thank you so much, Eva, for these nice words. And it's always a pleasure to organize such a great event together. Good afternoon. I'm very glad to be here. And first of all, my thanks to the Warsaw Bar Association and the Council of Europe and the European Union counterparts, with whom UNHCR had the great pleasure to to co-develop this important project today. Many thanks also to all our experts, I mean high-level experts, whose involvement and dedication really helped to make the event a huge success. So yeah, I'm Delphine Leneutre, and I work for the UNHCR representation to the European institutions in Strasbourg. And since several years now, I have the pleasure to co-develop the HELP online courses on asylum issues with the Council of Europe. And I mean, I'm really impressed by the quality of these courses and the even growing success and increase of interest in these online courses. So the very successful and informative seminar today is a great illustration on how our joint forces between our international organizations, but also between legal professionals in Europe, can contribute to a better understanding of European and international standards and to better address actually the challenges occurring in such an unprecedented humanitarian context. The response to the Ukraine refugee situation has highlighted Europe's capacity for an innovative and protective approach to asylum. Poland has been generously, hosting the largest population of Ukrainian refugees, or better to say refugees from Ukraine in Europe, and we have rarely seen such a wave of solidarity in Europe. So now really comes the time for more consolidation, as was highlighted today, but also equal access to rights for all persons in need of international protection and long-term protection solutions. I'm thinking here in terms of integration. We have seen that 67% of refugees from Ukraine had the intention, to stay longer in the neighboring countries to Ukraine. So the triggering of the Temporary Protection Directive within the European Union has really ensured a coherent and approach on how to manage finally mass flows with the swift access to safety, documentation, and human rights, albeit of course with some different interpretations from one country to the others. We heard earlier today from UNHCR and today's legal community that the range of administrative but also practical and legal barriers still exist, and the reality, to take your words, is not so rosy, in particular regarding the persons in need of protection who are falling outside the scope of the Temporary Protection Directive. So these challenges are of course different from one country to the other. All are not affected equally by the situation. So, as has been mentioned several times today, access to rights is particularly difficult for undocumented refugees or stateless persons. And in this context, allow me to draw your attention to what High Commissioner Filippo Grandi has already highlighted at the very beginning of the crisis, that any acts of discrimination or racism must be condemned and all people must be protected. The other crucial point I wanted to highlight from this event, from this fruitful discussion, is the role and the importance for the legal professionals and other persons providing information and assistance to perfectly understand all the standards. Lawyers, magistrates, really judges have a key role to play in the protection of refugees when dealing with cases linked to procedural safeguards, addressing reception issues, protection of vulnerable persons. These decisions will have a major impact on the asylum procedure and the protection of fundamental rights of persons falling under UNHCR's mandate, and will even then have an impact on the integration of these persons. So the discussions held today in the room, but also online during the coffee break, the lunch break, made it really possible to share experiences and good practices, and I hope will help lawyers who will face similar situations on how protection and assistance needs may be assist in a timely, fair, and efficient manner. So the exchange today will not stop, thanks to this innovative eDesk platform, which even is extended to more people now in different countries, in different member states of the Council of Europe. And so from the discussions, but also in view of the challenges and shortcomings identified today with regard to the situation in Ukraine, but also reception conditions, information needs were highlighted, but also child protection, the lack sometimes of identification of some vulnerabilities, and stateless persons, I would like to make two suggestions to help. That the joint health course on the protection of refugee and migrant children, which we have developed jointly 2 years ago, and which is fortunately already available in Polish and in some other languages in the region, could be included in one of our next launching events. And the other thing I was thinking, in view of the high interest in today's event, that the protection of IDPs could become subject of a next eDesk seminar. The protection really of internally displaced persons in Ukraine. So thank you again for all the fruitful discussions and exchanges. I hope the event answered the majority of your questions and concerns. There are still a lot of concerns, unfortunately. So thank you for your attention, and I will not delay too much the closing and the cocktail moment, so I give the floor to our dear Olga.
I don't know, maybe you want to.
You can, after the homework that Delphine gives me, you can have the floor.
Okay, thank you very much, Delphine. And I have a very pleasant mission, in fact, to thank everybody. And I will start, first of all, from our hosts, Warsaw Bar Association, and very, very kind and very helpful colleagues, Polish colleagues here who you have seen yourself how warmly they accepted us here, and certainly it's due to them also we have this possibility to be in these premises. And thank you to all management and to all staff of Warsaw Bar Association. I would like also to thank to our partners of this seminar, European Union, European Commission, who provided also the institutional assistance and very good experts. As you've seen, without these experts, we could not receive such a good feedbacks, and certainly UNHCR. So we discussed this idea together at the beginning, and today it's implementation of this idea, and I think it is very useful for everybody, not only for our institutions, but for all legal experts who were present and who will be able also to see the seminar and on the online, because we had online transmission and it is registered, so you will be, if you would like to see once more some items from some presentations, you can do it anytime on our side. I can also would like to thank Special Representative on Migration Issues of the Council of Europe, the Secretary General of the Council of Leila Kayachik, who supported this event also, and who supports the issue in general of protection of Ukrainian refugees in all your activities, latest activities. And also great thanks to all of you, all legal professionals, without whom this seminar would not be possible, because it is addressed to your interests. And first of all, I would like to thank Ukrainian ladies who came directly from Ukraine, Evgenia and Yulia. I think it was not easy to come, but I think you profited, I hope you profited from this event. And all of you who make this event successful, I hope. Also, I think that today exchanges gave us a lot of replies to very important issues of concerns of your practice, but also posed new challenges for us. And I think there are issues which we took note of and we will be able to develop in our further activities. I would like to thank Eva Pastrana, who is head of Division of Human Rights of the Council of Europe, Human Rights Education, because it's due to her very efficient and sense of urgency this project was possible. This project was launched very quickly, and she supported the idea of special project on Ukraine, which has not been planned in the budget of the Council of Europe, and that's why we can do it quickly. And this project also foreseen legal adaptation of several help courses online, which will be in Ukrainian language. 4 courses already now are translated, and I think we will also plan some TO training and other activities. And finally, I would like to announce a new event which will be held also here in Warsaw, taking this possibility that we are here. It will be on the 20th of October. Our help program will launch in cooperation with Ukrainian, with Office of Special Representative on Migration of the Council of Europe and UNHCR, the course on asylum and migration in Polish language. So everybody, especially the Polish practitioners, are welcomed to take part in this seminar. And finally, thank you very much for technical support, for the company who provided us this online possibility of video recording and video transmission, our interpreters, which is Ukrainian company, in fact, because we have Ukrainian language here, and all staff of Warsaw Academy who are helping us today. I hope very much that, I want also to thank, as it was mentioned, all people, all legal practitioners in European countries who are helping Ukraine. I think that today this event was evident that there are enormous efforts, unprecedented efforts in this domain, and we should be grateful to this, and we should encourage this very important work. And thanks a lot for you, for lawyers who defend the human rights. And this is our main mission of the Council of Europe, to defend the human rights, rule of law and democracy. And without you, it would not be possible. Thank you.
Thank you, Olga. I think we are finishing on time. Okay, so yes, thanks to all of you who came here. Thanks to Olga, thanks to Delphine. I also wanted to just say that this is not the only thing that the Council of Europe is doing. We're doing a lot of things. I think the Council of Europe is also helping the prosecutor's office. And I mentioned it quite quickly this morning, but we are updating a key help course for Ukrainians, is the prohibition of torture. And we are developing, finalizing to be ready by the end of this year, a specific module on ill treatment during armed conflict. So that will be very, very useful. We also have a new course that has not been even publicized, though it was meant for times of peace, not of conflict. However, it may be interesting. It is human rights in the armed forces. As said, it was meant for times of peace and not times of war. It had also a gender dimension, okay? Also the gender dimension in armed forces. But you see that there's a lot of things that we can still offer. Once that we go back now home to Strasbourg, together with our partners and with Olga and I, with our partners. We'll see how we can move on. The Council of Europe is also updating its strategy for Ukraine for 2022 or 23, 25, and we'll see how we can continue supporting Ukraine, which in this regard does not only mean work in Ukraine, but work for Ukrainians regardless of where they are moved. We heard today from Olga from UNHCR. We're talking also about an audience, a big audience is Ukrainian diaspora, if I may. It's a very digitalized. It came just after COVID, so this is an advantage for all of us working using digitalized media. So thanks a lot. Thanks to the Bar Association of Poland. We still have some things also with the Warsaw Bar, with Magda, with Malgorzata, we'll continue, Philip. So thanks a lot, and then we can enjoy the cocktail, and I think an applause for our Ukrainian colleagues who are here.
Record.